Good afternoon, ladies and gentlemen. Welcome to the George W. Norris Legislative Chamber. The afternoon session is about to reconvene. Senators, please record your presence. Roll call. Mr. Clerk, please record.
There's a quorum present, Mr. President.
Mr. Clerk, for items.
Thank you, Mr. President. Communication from the Executive Board indicating legislative bills 813, 814, 818, 282, and 799 have been designated as Speaker major proposals. That's all I have this time, Mr. President.
Thank you, Mr. Clerk. Senator Geist, you're recognized for a point of personal privilege.
Thank you, Mr. President and colleagues. I just want to let you know that as of noon today, I announced my intention to step down from my legislative seat, which will be effective the end of day tomorrow, 11:59 p.m. It has been an honor of my life to serve here with all of you and to serve my district. Those of you who know me well, you know that I give 100% to everything I do. And in order to do that, I've decided to step aside so I can give my full attention to my other commitments. I'm not going to belabor the point. I wish all of you very well. I wish you the best this session, and God bless you all. Thank you.
Mr. Clerk, for items.
Mr. President, select file, first bill, legislative bill 683. First of all, Senator, I have E&R amendments.
Senator Ballard for a motion.
Mr. President, I move the E&R amendments to LB 563 be adopted.
The motion is to adopt the E&R amendments. All those in favor state aye. Those opposed, nay. The E&R amendments are adopted. Mr. Clerk, for the first item.
Mr. President, First Amendment, Senator Duncan will move to offer AM 1096.
Senator Duncan, you're recognized to open.
Thank you, Mr. President, and thank you, colleagues. So I want to start by sort of saying that AM 1096 is meant to be a technical fix. I rise generally in support of LB 683. I was present not voting on the underlying one because I had questions regarding the subject matter of my amendment that I'm going to get into more in a minute. I do think that this amendment seeks to sort of make the bill operate a little bit cleaner and just clarify some things that I had conversations with Senator Geist and others about. So just to situate us and make people understand sort of what we're talking about. So obviously, LB 683 seeks to create the Nebraska Broadband Office. In my reading of this bill, I tried to look at it as a practitioner's perspective from the legal perspective with regard to whether or not the process for an appeal based on a decision by the Nebraska Broadband Office is clear. And what caught my eye was on page 5, line 16, subparagraph 3, it says, if any final decision of the Nebraska Broadband Office relating to funding for broadband projects is appealed to the district court, the appeal shall, except as to cases the court considers of greater importance, take precedence on the trial docket over all other cases and shall be assigned for hearing, trial, or argument at the earliest practicable date and expedited in every way. So when I was reading that, the first thing that sort of popped out to me was this line with regards to the appeal shall, except as to cases the court considers of greater importance. Having operated and worked in the district court here in Lancaster County, where it's my understanding these cases would ultimately be heard, that seems like a very difficult decision for a district court judge to make. And I don't want district court judges to be placed in a position where they're needing to decide what the actual level of importance is regarding to individual matters that are on their docket. And what I mean by that is district court judges take up civil cases, they take up criminal cases, they take up a number of different kinds of cases that all have varying levels of importance to those involved. And the language of except as to cases the court considers of greater importance seemed problematic to me. I think that puts the judges in a really difficult predicament of deciding what is more important and what's not. And so that led me down the path of trying to figure out why that language was in there. I talked to some people during general file and also in between general and select, and my understanding is that the intent of that language was to sort of expedite or speed up this appeals process. And so the amendment before you, AM 1096, simply seeks to remove the language except as to cases the court considers of greater importance. What the effect of this amendment does is it takes out that sort of ambiguity of the importance of cases and instead just says that any appeal before the district court of a decision made by the Nebraska Broadband Office relating to funding shall take precedence on the trial docket at the earliest practicable date and expedited in every way. So what that means is this is, I think, seeking to speed up the process in a way that is what the goal was, but it still has at the earliest practicable date, which means it allows the district court a little bit of flexibility because they can't obviously schedule something the next day if that's not practicable. So this is intended to sort of balance those interests. And I asked a number of these questions to somebody on the committee who I thought would have that information. So I was wondering if Senator DeBoer would be willing to yield to some questions here to kind of clarify what this amendment does and what the process is.
Senator DeBoer, will you yield to some questions?
Absolutely.
So Senator DeBoer, we talked about this a little bit on general, but just to clarify, decisions that are made regarding funding from the Nebraska Broadband Office, any appeals process, is that still pursuant to the APA the way that a regular administrative procedure would be?
Yes, any appeal from the broadband office would go through the APA procedure.
And so what's the intention behind subparagraph 3 here in the language that we're talking about? Why was that added in?
So the problem is with these sorts of decisions, what you have is a situation where delay actually makes a decision, because these are grants which are time sensitive, so that if someone who is asking for a grant is having an adjudication by the broadband office about whether an area is served or not, if that takes a whole lot of time to go through the process, to go through the appeals process, then that will actually run out the clock and effectually make their grant application sort of not work. So what we want to do is we want to expedite the process, because otherwise we can't have an effective appeals process if it takes too long. So currently under the PSC, when we have these grants, what will happen is the Supreme Court, if you appeal a decision of the PSC, it goes straight to the appellate court. It skips that district court step, goes straight to the appellate court, and our Supreme Court most of the time will reach down and grab those and take it up for the first time in the Supreme Court, which expedites the process. So what we want to do here is expedite the process now under the broadband office, so that we do not, by virtue of allowing delay, actually defeat the whole purpose of having a challenge process.
So do you think that, based on sort of your expertise in that area, do you think that AM 1096 effectuates that goal of speeding up the process by removing that discretionary language?
Yes, I think that AM 1096, to the extent that we are all clear that we're going to go through the normal APA process, is effective in suggesting that these appeals need to go quickly through the district court as soon as they can, and that is, I think, an effective way of effectuating what the intent was.
And you were in favor of LB 683, correct, when it came out of committee?
Yes, the newspapers did not clearly report that I was in favor of this bill, but in its current form with the amendments that we put on in the committee, I am in fact in favor of this bill and have been arguing for it, despite what you may have read.
Okay, and would you remain in favor of it if AM 1096 is added on?
Yes, I think AM 1096 is a good addition.
Okay. Thank you, Mr. President. So generally speaking, just to reiterate that, 1096 you see as a friendly amendment to 683.
I think it is a good amendment that, should we adopt it, will do exactly what we intended with the committee amendments.
Thank you. So, Mr. President and colleagues, I just wanted to reiterate that. I think it's helpful to have that perspective from somebody on the committee who was in favor of LB 683. As I said earlier, I spoke to Senator Geist about this previously. I've spoken to a number of other senators on the Transportation and Telecommunications Committee. This is intended to be a friendly amendment to clarify that the purpose of the subparagraph 3 is to expedite these appeals. Again, I think it allows plenty of wiggle room with regards to the practicable date to allow district courts to schedule this when would work for them, while at the same time actually trying to speed up these appeals so they don't get continued out for months upon months, if not even years, just because there are always pressing matters on a district court docket, and I would hate for these appeals decisions to never get heard by the courts. So, colleagues, I would urge your support of AM 1096. I'm happy to answer any questions that anybody might have about it. I don't intend to continue talking about it on the mic. It's a friendly amendment. I believe folks on the committee are in favor of it, or at least that's what it seems like to me. But if you have any questions about the function or the form of how this would operate, I'm happy to answer those. Thank you, Mr. President.
Thank you, Senator Dungan and DeBoer. Mr. Clerk. Senator Blood, you're recognized to speak.
Thank you, Mr. President. Fellow senators, friends, all, I stand in support of Senator Dungan's amendment, but I do not stand in support of the underlying bill. And I am hoping just once everybody would listen to the reason why before you all push green on this button like robots. Because I have a lot I want to share with you. So what's really stuck in my craw about the underlying bill is that the governor already created this office by executive order. So the time that we've wasted on this bill is because somebody decided that we need to codify this effort. And I find that really frustrating. In fact, I think it's funny that we can't codify child labor laws here in Nebraska because I was told it wasn't needed, even though 10 more states need to get together to codify it in order for it to be in our U.S. Constitution because, you know, we love children, but apparently only when it's a particular bill. We heard several senators say that broadband must be taken away from the PSC because what's happened, or should I say not happened, with broadband is mainly the PSC's fault. So to be honest, it's really the fault of this body and its lack of knowledge now and in the past when it comes to technology. We really need a technology committee, by the way. But we feel that the PSC is so incompetent that we still decided that we could still let them handle certain grant programs pertaining to broadband. So either they can do the job or they can't do the job. Make up your mind. What I don't see in this legislation are the very things that would have prevented our constipated efforts when it comes to broadband. Why doesn't this bill have an accountability aspect? Where is the language that says we codify this office but have the expectation that any company that applies for state or federal broadband funds are required to give us specifics, which, by the way, is why we're in this mess right now, because we in Nebraska don't measure what we treasure. We give money out to big corporations and we let them go on their merry way and we don't care, and then we act surprised when we don't get any bang for our buck. I want to know where they will be building and what speed their projects are offering. I want that language in a bill like this. That's still not necessary. I want to go down into the dirt and know what our cost per mile is. There were one or two senators who talked about speed during a previous debate. Where's the requirement for independent speed testing? Let's codify those things. My big thing when it comes to broadband is that I want to pull back the curtain. Let's force our telecommunication companies to publicly report their progress since they are using gifted funds. We haven't done that. We don't do that. Not really. And then we wonder, going all the way back to around 2005 when Heinemann was governor, why we're in the mess that we are in. Are they using fiber? Are they using Wi-Fi? We don't know. Show me how we know. Show me how they report back to us in a way that we can utilize the data to make better decisions. You can't. We may very well have a new regime, but the previous two regimes at the executive branch left a long list of problems that had to be corrected. And much of that was because things were not transparent. And that is the issue with moving everything over to the governor's office. From DHHS to overcrowded prisons and much, much more, I am not a fan of codifying something that is already in place. So when it goes south, guess who they're going to point at? It's not going to be the executive branch. It's going to be you.
1 minute.
We saw that during Heinemann's reign of terror, right? Or should I say error? I'm going to get back on the mic, and I'm going to start walking you through historically why this underlying bill is ridiculous, and it is irresponsible to move this through any further than select file. It needs to go away. It needs to have a speaker's hold. It needs to be somewhere besides in front of us, taking up time. With that, I'd yield back any time to you, Mr. President.
Thank you, Senator. Senator DeBoer, you're recognized to speak.
Thank you, Mr. President. I've been talking with some of the other members of the Telecommunications and Transportation Committee about this amendment and whether it would effectuate what our idea was with the committee amendment. And I think we've reached some agreement with some of us, at least, that it will do that. So I was wondering if Senator Geist would yield to a question.
Senator Geist, will you yield to a question?
I will. Senator Geist, I know we've been talking under the balcony about this amendment with Senator Duncan and others. Do you feel that this amendment will be a friendly amendment that effectuates what we're trying to do with our committee amendments here?
Yeah, I do. I think this is good. It doesn't give specific days to what is expected of the judiciary, but it does give some guidance. So yes, I think it achieves what we're after.
Thank you, Senator Geist. Senator Bossman, you also have been working on a lot of these broadband issues with us a lot and know about the problems or the concerns that might happen if there was a delay in these kinds of challenge processes. Do you think that Senator Duncan's amendment, as it is outlined on, would allow us to achieve that goal of not having delays in the adjudication process?
Senator Bostoman, will you yield to a question?
Yes, I will. And yes, I do support AM 1096, and I do agree with your comments and Senator Duncan's.
All right. Thank you, Senator Bosselman. Anyone else? Senator Frederickson, we'll ask you. You're sitting here.
Senator Frederickson, will you yield to a question?
Absolutely.
Senator Frederickson, you've had time to listen to the discussion about AM 1096 from Senator Duncan. Are you confident that this will help us to achieve the goals of the committee amendment to expedite this process?
Yes, I am. I think this allows for obviously the adjudication in an expeditious way. So that's what we're going for. So I'm in support of the amendment.
All right. Thank you. All right. Well, I want to say thank you to Senator Duncan for helping us to come to this conclusion. And I want to urge all of my colleagues to vote in favor of AM 1096 and in favor of LB 683. Thank you, Mr. President.
Thank you, Senator DeBoer. Senator Michaela Cavanaugh, you are recognized to speak.
Thank you, Mr. President, colleagues. So I was trying to find Senator Duncan's amendment. Senator Duncan, would you yield to a question?
Senator Duncan, will you yield to a question?
Yes.
Thank you, Senator Duncan. I thought that I had a copy of the bill as adopted. What does your amendment do?
So currently, an appeal that goes to the district court, the language in here says, any final decision of the Nebraska Broadband Office that relates to funding, when it goes to the district court and is appealed there, that they have to set it. It says specifically, it says, appeal to the district court. The appeal shall, except as to cases the court considers of greater importance, take precedence on the trial docket over all other cases. My concern with that is it seemed ambiguous as to, I felt like that was placing maybe the district court in an uncomfortable position of needing to decide, well, what is a case of greater importance? And when you're working in the district court, sometimes a case that's a low level, let's say criminal offense, may be coming up on the very end of its statute of limitations. So does that mean that that's more important, or is a murder more important? Or if you're looking at civil cases, is a divorce more important than this? And so that language is just ambiguous enough because courts don't rank their cases in order of importance. So I then asked folks, what's the goal of this? And they said the goal was to make sure these appeals happen as quickly as possible. And so in an effort to make sure that happens, this amendment just cuts out the language, except as to cases the court considers of greater importance, because then all read together, it says that these shall take precedence, these appeals shall take precedence, and the court has to schedule them at the soonest practicable date. So the language of practicable in there still gives the court flexibility to say, well, I have a jury trial coming up next week. I can't hear this case immediately, but as soon as they possibly can, then they hear these appellate cases. And so if the goal is to get these done ASAP, this still provides the courts flexibility to do what they want, but ensures these appeals are heard in a timely manner so they don't kind of languish, waiting, continuing down the road because other cases were pending on the docket.
Okay. Thank you. That was helpful because I noticed it said after the comma, strike line 18 and 19. And I was like, okay, I got to find the comma. And then I find the comma and I'm not a lawyer. So thank you. That was helpful clarification. I probably will vote for AM 1069 because that sounds like something that we probably want to clarify. I still am opposed to LB 683. So when we debated this on general file, I spoke about a lot of my opposition to LB 683. And primarily, it's not about the broadband office itself. It's about what we are doing by taking away an authority from an elected body and giving it to the administration. And I think that we probably need to seek an AG's opinion on the constitutionality of it, because it is very clear in our Constitution that we cannot take an authority away from the Public Service Commission that pertains to common carrier.
1 minute.
And give it to the administration. That would be unconstitutional. We have not defined common carrier, but common carrier could, or we have not defined broadband as common carrier, but it could be defined as such at a later date and an immediate date. So I think before we do something like this, we really need to have that clarification of whether or not it's constitutional. So I think that we should be asking for an AG's opinion on the constitutionality of what we are doing with this. I think I'm about out of time, so I will continue on my next turn.
Thank you, Senator Kavanaugh. Senator Blood, you are recognized to speak.
Thank you, Mr. President. Fellow senators, friends all, I was a little loud on the first part because it was so loud in here that I just wanted everybody to make sure that I was heard. So I'm going to take it down a notch. But I hope you are listening because I think it's an embarrassment if we move this bill forward. I still stand in support of the amendment. It's a good amendment, but the underlying bill is not. When did we waste taxpayer dollars on codifying something that already existed? Actually, I can name several instances, but. So in recent years, the state of Nebraska has taken action to study gaps in the state's internet coverage, and we've invested in the expansion of high-speed internet. And I'm going to talk a little bit about the history of what we've done. And there's a common theme throughout all of these bills and the reason why certain parts of Nebraska have been ignored. And I'm hoping you guess what that is. So in 2018, Governor Ricketts signed LB 994 into law, and they created the Rural Broadband Task Force, which was supposed to alleviate the issues of the rural areas not having adequate or any, in some areas, broadband. Ed Toner was the state's chief information officer at the time, and he was the chair of the Nebraska Information Technology Commission. We love to put together commissions and committees, workforce groups, but it seems like there's a lot of meetings, but never any real action. The task force has worked to evaluate, or had worked to evaluate rural Nebraska's broadband needs, and they recommended actions to increase high-speed internet access. Gee, that was in 2018. Is it kind of surprising that we were behind on that compared to other states? Again, no technology committee, and we lack the knowledge when it comes to technology in this body to make good decisions sometimes. In 2020, the state of Nebraska allocated nearly $30 million. That was from the federal coronavirus assistance to connect more than 20,000 households with broadband. In 2021, the governor signed the Rural Broadband Bridge Act into law, LB 388. We invested $40 million, $20 million per year, right? To help another 30,000 households get broadband connectivity. Tens of millions upon tens of millions upon tens of millions of dollars. Did we ever get a report back on that in the body? I don't think so. In 2022, Governor Ricketts signed LB 1144 into law, and that amended the Rural Broadband Bridge Act, and that changed the required match from 50% to 25% because we wanted to make it easier for people that got grants that were working on projects in high-cost areas. Because we know these big companies don't want to do business unless they make a profit. So we wanted to make sure that they made a good profit. And it made it more financially viable for providers to construct broadband in rural parts of the state. I'm curious, where's the tracker for that? Can anybody point me to that, where I can get that information? I'd like to see that. In September 2022, Governor Ricketts told us that we already had the legislative framework. We have the legislative framework and operational processes in place to manage all of our state and federal broadband grant programs to expand access to high-speed internet. So did Governor Ricketts lie to us? We've already got it in place. I don't know. Maybe someone can come up and tell me the answer, because I don't know. I only had a few minutes to throw some of this together. In 2022, it was announced that Nebraska received $5.6 million in federal grants, and the working group, Connect Nebraska, yet another working group and another fancy name.
1 minute.
They would move forward to make sure that the funds were put to use. But yet, when you look at the bill, they talk about creating a strategic plan, because apparently none of the other strategic plans or plans in general have worked. Why do we think those haven't worked? And I'll address that the next time I'm on the mic. Thank you, Mr. President.
Thank you, Senator Blood. Senator Conrad, you are recognized to speak.
Carol, do you want time? I'd yield my time to Senator Blood if she so desires.
Senator Blood, you have 4 minutes, 50 seconds.
Thank you, Mr. President, and thank you, Senator Conrad. So let's talk about strategic plans. I talked about this my freshman year. It was one of the first times I ever talked on the mic when we were going to approve money for a strategic plan when we had a commission that had done one the previous year. Strategic plans are living, breathing documents. Every time you have a whim, you don't change the strategic plan, you amend the strategic plan, because either it was a good plan or it wasn't. Just because you get a new department head, just because you get a new grant, you don't get a new strategic plan. If you have a good strategic plan, you have the who, what, where, when, how for success, and it is a pathway to that success. So why do they need a new strategic plan? Either they don't need a new strategic plan or they've already done it based on the fact that we're just codifying, or the one that the Ricketts administration, one of the many ones done by the Ricketts administration, were crap. I don't know. And I can't tell by the way this bill is written. So it says in the bill they're going to conduct state advocacy on broadband issues at the federal level. So why do we have the Connect Nebraska group? What are we trying to create here, and what are we trying to do, and who's going to be doing it? That's not clear to me in the bill. They're going to provide resources and information to the public through a website and other communication modes. Hello? Broadband.nebraska.gov/home, which used to have Governor Ricketts' signature on it, has been replaced with Governor Pillen's signature. So again, what are we doing here? What are we voting on? This already exists. They want to create a website of information. That website of information is already on the internet. And it's actually a pretty good website considering some of the websites we have in this government. Now, I can't tell you if it's secure or not. I haven't looked at that yet, because we used to have a lot of different pages within our government sites that were not secure and were open to hackers. Department of Labor is a really good one that I'd like to point out at another time. So what's on this website? Well, a lot of the things that we talked about that supposedly this bill was going to do. That website, nobody's listening. I'll just make sure I print out the transcripts and say I told you so in a year. So what's on the website? Broadband availability map. Broadband grants. Thank you, Senator Erdman, for listening, by the way. All right. You can subscribe to the newsletter for updates on broadband. What grants are available? What's going on with the speeds? What's going on with the process? They even have a digital equity statement. Very forward-thinking. So what are we doing with this bill? Is it just a vehicle to attach other bills on? Which I have an issue with one of the amendments coming up too, so this is not the last you're going to hear about today. And again, it's another thing of what are we doing when there has already been statements made by the governor's office that are executive orders? Why are we codifying that stuff on the floor? What is the purpose of an executive order? Are we the executive branch? We are not. Is the governor's office the legislative branch? They are not.
1 minute.
When we went through training our freshman year, we were told there's a definite divide. Why are we trying to blur the lines? I have a lot of theories on that, but I'm not sure everybody would agree about why we're trying to do that. But the one thing I do know is that we are ultimately responsible for this train wreck we are creating if we vote green and if we push this through. Thank you, Mr. President.
Thank you, Senator Blood. Senator Michaela Cavanaugh, you are recognized to speak.
Thank you, Mr. President. So, LB 683, AM 1096. I am going to vote for the amendment, but not the bill. I just glanced out into the rotunda and I saw Herbie Husker. I said that very cautiously because for a second I was like, if I get that wrong, I'm pretty sure I'm going to be run out of town. I saw Herbie Husker because it's I Love NU Day. And as an alum of the University of Nebraska Omaha, I'm very excited that they're here. And I do love the university. I also love our state colleges and our community colleges. We have some great opportunities for education and some great opportunities when it comes to getting into the industry of telecommunications and transportation. So, and the university provides a lot of those opportunities, as do the state colleges and the community colleges. And so, with continued investment in our post-secondary education institutions, hopefully we can make up ground in recruiting and retaining an educated workforce. So the broadband bill, this broadband bill, there's more than one broadband bill, but this particular broadband bill is really the authorizing language to take away a function, a duty of the Public Service Commission. It is taking that and giving it to the administration. And a very real concern I have is the constitutionality of this. So I had started to talk about this, the common carrier. It is in our Constitution. Sorry, I have a copy of it here. It is in our Constitution that the Public Service Commission shall not have, let's see here, A legislative act or statute may constitutionally divest, which is what we are doing, divest the Public Service Commission of jurisdiction over common carriers to the extent that the legislature, through specific legislation, has preempted the Public Service Commission in control of common carriers. But then it goes on to say the legislature cannot constitutionally divest the Public Service Commission of jurisdiction over a class of common carriers by vesting a government agency, body of government, or branch of government, except the legislature, with control over the class of common carriers. The concern, colleagues, is that we have not defined or clearly stated if broadband falls under common carriers. It hasn't been defined as a common carrier, or stated that it is not a common carrier. It is not gotten up to speed. Our language, our statutes have not gotten up to speed with the technology. So
1 minute.
if the potential exists for broadband to be defined under the common carrier definition, what we are doing is unconstitutional. And we should be actively seeking an answer to that question. Could broadband be defined as common carrier? Does it meet the threshold, the requirement, the criteria of what is a common carrier? And if it does, then we should proceed very, very lightly. Very lightly. So that is one of my more significant concerns that I am going to continue to talk about, because I don't believe that we as a body are paying attention to the constitutionality of what we are doing in setting up in statute this office. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Blood, you're recognized to speak. This is your third time.
Thank you, Mr. President. Again, I stand in support of Senator Dungan's amendment, but I want the underlying bill to just go away. I would like to see us maybe put a speaker's hold on it while we write a letter to the Attorney General's office to really explore what Senator Kavanaugh has been talking about. But I want to go beyond that. When you guys push green today, as I'm guessing you all will, you are voting for something that is unnecessary. And with that, I actually would like Senator Dungan to yield to a question, because I think he knows the answer to this.
Senator Dungan, will you yield to a question?
Yes.
Senator Dungan, could you describe what an executive order is and its purpose?
An executive order? I don't have the definition here in front of me, but I know the executive branch is allowed to issue executive orders that don't apply to other branches. They're allowed to essentially order the parts of the executive branch and those who answer to the executive branch in order to do certain things to effectuate certain goals, and that other branches of government are not necessarily held accountable for the executive order. And so, for example, you couldn't do an executive order that would tell the legislature to do something. It would be stuck to just the executive branch.
So when the executive branch forms a committee, or when the executive branch says that it's going to allocate or accept funds and do something with them, do they need the legislative branch to codify that to make it happen?
I'm going to be 100% honest with you. I'm going to give you the really annoying lawyer answer, which is probably it depends. And I don't know the exact details of what we're talking about, so I don't want to speak out of turn, but I understand the point you're making. And I believe, generally speaking, there is a separation of powers there with regard to an executive order in the executive branch.
Right, we're the legislative branch, right? I used to be on the Bellevue City Council. It's a weak mayor system. All the legislative power was in the city council, same kind of thing. Would you say that sounds right?
I believe so, yes.
All right, you don't know anything about the Bellevue Council, but trust me, it's
I'm from
true.
Lincoln, sorry, yeah. That sounds right.
Yeah, the mayor's a figurehead. They can't spend money unless the council says they can spend money, which is kind of great, right? Because it gives you a good balance. So I appreciate that. Thank you, Senator Dungan. So we have really been working kind of hard on this issue for at least 20 years. I remember when Governor Heineman was in office, it was like around 2005. And this body was pushed, I can't remember if it was passed, but I remember that it got through at least 1 or 2 rounds. This body voted to prevent Nebraska cities and towns from offering municipal broadband. So that's probably sounded like a good idea at the time. Let's go ahead and give it to all the big corporations. Let's give it to the lobbyists and their clients out in the rotunda. But when we did that, we limited our options to expand broadband. Now, I'm going to try and bring up these transcripts because I know we're going to have more talking on this bill. But what that tells me, again, is that what we are dealing with are the sins of the past. And we can say, well, we want to fix those sins of the past, Senator Blood. Yes, we want to fix those, but we don't fix those by codifying something that's already put into action. After reading that bill and seeing what we already have in place, to me, it almost feels like we're trying to give our governor a gold star so he can use that on his platform to say that he accomplished something. And I get it. That's good PR. I'm not saying that wasn't a good idea. I'm just saying that that's not our job in this body. That's what I'm saying. Our job is to craft legislation and move that legislation forward. Our job is not to codify executive orders. Because if we start doing that, why are we even here? Our job is to craft good policy, not to lift up the executive branch. They have their own executive orders. They can move forward without us doing this. Outside of giving a ride to several amendments, this bill serves no purpose. And when you vote green, we're just playing make-believe. Thank you, Mr. President.
Thank you, Senator Blood. Senators Jacobson and Wishart announced that in both balconies we have students, alumni, and supporters from the University of Nebraska system from across the state. Please stand and be recognized by your Nebraska Legislature. Senator Conrad, you're recognized to speak.
Thank you. I'd yield my time to Senator Blood if she so desires. Carol.
4 minutes, 57 seconds. Senator Blood.
Thank you, Mr. President. Thank you, Senator Conrad. Sorry I was being asked a question and had you tuned out. I apologize for that. So I was just asked the question, can the governor do this if we don't pass this bill? That's the point. The governor is already doing this. We don't need to pass this bill. It doesn't make sense. We're playing make-believe. Now, the other question I was asked was, well, the maps that are on the website don't show everything. And that's absolutely right. So the committee that's in charge of that should correct it. We don't need legislation to change that either. The website in general is a really good website. It is modern, it is easy to peruse. It doesn't have all the data that we need on it right now. So again, what are we trying to prove here? Are we trying to prove that broadband is important? No, you can talk about it on the mic and say those things, but this bill doesn't change any of that. It doesn't create good transparency. In fact, it does the opposite. I mean, we know that Mr. Goins stepped down today. There's a really good example why transparency is important, guys. If we give this all over to the executive branch and take it away from an elected body, as Senator Kavanaugh talked about, we are doing the opposite of transparency. What we are doing is giving it up to the universe so it can come back to us and bite us in the butts. Prisons, DHHS, Nigerian crime rings, Russian mafia, giving them DOL dollars from unemployment. Like, how many times are we going to screw up because we can't see the forest for the trees, right? You know what's interesting is when people talk on the mic, how many people's backs are turned. Are you listening? Senator Lowe, you usually watch. You're not even watching it on your laptop today. Senator Arch, thank you for that smile. I just really want you to think about what pushing green means. Pushing green means you're ready to give things up from an elected body to the executive branch. It means that you don't care about the history of the executive branch screwing things up. And it also means that you are willing to codify something that already exists. So the bill does nothing. The bill doesn't make broadband better. The bill doesn't change anything about broadband. Again, it talks about a strategic plan. What's wrong with all the other strategic plans? It's a living, breathing document. Did the Ricketts administration screw that up? Come and say that on the mic, and then maybe I'll agree with you. If not, it is this administration's job to tweak that strategic plan, because God knows we have spent tens of millions and tens of millions of dollars on broadband. We did not measure what we treasure. We just gave it up and said, give us broadband. We don't really know what to ask for, but go ahead and do it. Now, I will give certain members in this body credit. The last few years, we have been better about tracking those things, but it's not enough. Our fear, not all of us, of technology have prevented us from asking the right questions. And so we depend on those lobbyists out in the rotunda, the people from the big companies that make a living doing this, to give us the information that we need to make our good decisions.
1 minute.
You can tell that by what happened during Heinemann's time when we decided to only allow these big companies to go ahead and take control. Friends, I am begging you, put a speaker's hold on it, do something with it, vote red. If that bill goes through, we are playing make-believe. We are doing nothing. Why are we in this body if we're just going to do pretend? I'm not voting for a bill that codifies something that's already in motion, that already has the ability to do all the things that it claims it wants to do in the bill, when those things already exist. And I hope to God that somebody is listening on this floor, because that's not the action I'm getting right now. With that, thank you, Mr. President. I would yield any time I have left.
Thank you, Senator Blood. Senator Lowe, you're recognized to speak.
Thank you, Lieutenant Governor. I just stand to speak in favor of LB 683 and AM 1096. And I wanted to welcome the UNK Lopers to the balcony today. Go Lopes. Thank you.
Thank you, Senator Lowe. Speaker Arch has some guests in the south balcony, fourth graders from La Vista West Elementary. Please stand and be recognized by your Nebraska Legislature. Senator Kavanaugh, you're recognized to speak. Michaela Kavanaugh, and this is your third time.
Thank you, Mr. President, colleagues. It's nice to see all the students here. I saw Chancellor Gold was up there. I think that he left when the last group left, but nice to see Chancellor Gold from UNMC here for I Love NU Day. And Dr. Cradaville, I think, was with him as well. Dr. Cradaville has been an amazing resource to the legislature during the pandemic. The university the Med Center had a lot of briefings for us, mostly over Zoom. And I'm just very grateful to Dr. Cradaville for all the time that he and all the other doctors at UNMC gave us and helping keep us up to date on everything that was happening as quickly as they could. And also for the Swiss cheese analogy, which is a great analogy. So the Swiss cheese analogy is the layers. So you've got a piece of Swiss cheese and it's got all the holes in it. And so it's like, if you just have one piece of Swiss cheese, something's going to get through the holes. But if you have multiple pieces of Swiss cheese, the holes start to get covered up. And so that was the analogy behind the multiple layers of protocols and precautions with COVID-19. and really any infectious disease. You want to use the Swiss cheese method, which is layering until all of the holes are covered up. So that's that will forever live with me, Dr. Cradaville, the Swiss cheese analysis. So LB 683, it's just, the broadband office, first of all, exists. The governor did an executive order and created the broadband office. It exists. The legislation gives it authorities. Fine. Except those authorities belong to somebody else right now. That's the problem. It's not what the broadband office is being tasked to do. That's not a problem. The problem is a new office has been created by executive order with a new authority that we have to divest from somebody else, and we don't know if it's constitutional. Problem. Big problem. So we should find that out. And I know there's a notion I don't agree with, that this is of the utmost time importance because of the timeline on submitting the strategic plan to the federal government. Well, we have a broadband office. We have a public service commission that has the authority. Both are really working together right now on the strategic plan. They can continue down that path until we make this change official in statute. But I don't believe that it is responsible for us to make it official in statute until we have an answer to that constitutionality question.
1 minute.
So this is kind of me telepathing to the Attorney General Hilgers that I think we should be writing him a letter asking for his office to weigh in on the constitutionality of whether or not broadband could be interpreted as a common carrier. If broadband can be interpreted to be a common carrier, if it meets the criteria of what a common carrier is, we are walking down a very reckless path. Very reckless. And if it's not, fantastic. Fantastic. I will zip it. If we are not walking down that, I don't know. If we are not walking down that path, then great. Then let's move forward. But I would like to know the answer to that before we do anything else. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Hunt, you are recognized to speak.
Thank you, Mr. President. I would like to yield my time to Senator Blood if she would like it.
Senator Blood, that's 4 minutes, 50 seconds.
Thank you, Senator Hunt. I would like to talk one last time on it, and then I'm going to put it to rest until we get to other amendments. I still stand in support of Senator Dungan's amendment. It makes a really bad bill better, but I don't support the really bad bill, LB 683, because again, it is unnecessary. Here's what I want to see when it comes to broadband legislation. I want to see accountability. We have lacked accountability in almost all legislation that we have put forward. We had the expectation that if we gave people money, they would provide broadband for us in rural areas. We always talk about running the state like a business. Well, here's business 101. If a business can't make money, they're not going to do it. They're only going to do areas that benefit them. Are you surprised? I don't think Senator Hunt would have a business that didn't make profits, because what would be the point, Senator Hunt? She'll tell you that, except unless you really enjoy it and you're willing to take it in the gut, but I can empathize with that one too. Not only do we not measure what we treasure, but it's not been transparent. We don't know the who, what, where, when, why, and how. And we really haven't ask that question very often when it comes to legislation that pertains to broadband, because in our desperation, in our need to help our rural folks and our folks in eastern Nebraska that live in impoverished areas, we rushed to give people money. We rushed to give them grants. And what happens when you do that? You lack transparency. We don't know, was it fiber? Was it Wi-Fi? We don't know, were they using subcontractors, which by the way, they usually do. And that creates a secondary problem. That happened when I was on the city council. What we had was we would hire a company that we thought had the best price or could do the best coverage, could do the best whatever. And the reason they could do that is because they would hire subcontractors, and there'd be layer upon layer upon layer of workers, which of course they have to do because you could never afford to have that many workers within your company to provide benefits, to provide vacation, to provide sick leave. So it's really a good financial decision to have subcontractors. But then what often happens is the subcontractors aren't really beholden to anybody. And so things don't always get done in a way that is appropriate. And quite often, those people at the bottom tier of that subgroup didn't get paid or didn't get paid what they were promised. And guess what? They usually get away with it. Because who laughs all the way to the bank? The big company. And that's the way the world works, friends, if you didn't know that. We need a technology committee. We do have an elected group that is responsible for these actions. We say that we don't trust them based on past behavior, but that past behavior came from us. Governor Ricketts himself said that we had the legislation in place. We're just asking the wrong questions. And now, after this fiasco of almost 20 years, we're willing to give it up to the executive branch. But that is our job to craft good policy, our job to put the guardrails in place, our job to create the roadmap to success. And you know what happens when we codify this, because I know you're going to do that. Guess whose fault it's going to be when things go awry yet again? And meanwhile, again, these big companies will be laughing all the way to the bank. And yeah, we are going to get broadband because we're already to that point. Come on, don't fool yourselves. Nobody's going to be a hero and all of a sudden like, look, we got broadband. Well, yeah, after 20 years, we're getting broadband. And yeah, we're investing in it. And yeah, we have the resources, but shame on us for the way we're doing it. Again, thank you for the time, Senator Hunt, and thank you, Mr. President.
Thank you, Senator. Senator DeBoer, you're recognized to speak.
Thank you, Mr. President. Well, I have an answer, so there we go. So Senator Michaela asked for an answer about whether or not broadband can be considered a common carrier under our laws, and the answer is no. It is not a common carrier under the 1996 Telecom Act, which is a federal act. It is not a common carrier, which is important because of federal preemption. They've occupied the field and they've said it's not a common carrier, therefore it's not a common carrier. So we have our answer, and we know that they are not a common carrier, which gets rid of the constitutional concern that Senator Michaela Cavanaugh had suggested she was concerned about. And so I think that's great that we know that piece. Another piece I'd like to point out, I've heard some concerns on the mic about why we're doing this. Isn't it already done basically by the governor's proclamation? And the reason that we're doing it despite the governor's proclamation is because with these kinds of grants, we want to make sure that we are not subjecting the state to liability. And there is the possibility that someone could challenge whether the governor's grant would be, or proclamation would be adequate to transfer this responsibility to the broadband office. And in order to avoid that liability, what we can do is we can put it in statute, which takes rid of that risk, takes care of that problem. And I also wanted to reiterate that I don't think the PSC has done a bad job. It has only been a pretty short amount of time that they have had responsibility for broadband. Broadband was not really under their purview until, I don't know, it was 15, 20 years ago. And in that time, we have not given them an astronomical amount of money at any given time to work on it. So it is understandable that we have not solved the entire problem of broadband in the state of Nebraska in that amount of time under the PSC. So I want to put out props to the Public Service Commission and certainly remind everyone in the body that we are not taking all the responsibilities away from the Public Service Commission with the broadband office. Rather, this is a sort of conglomeration of certain responsibilities, for example, for the mapping and for putting together this long-range plan, which is required in order to get the BEAD funds, into one person's hand to kind of try and get that part of the process all into one place and expedited. The PSC will remain an active and important player in broadband, both with the state monies through the Broadband Bridge Act and in the short term through the capital projects money, but also because they will have to now and into the future handle those high cost areas and the funds to support those with the NUSF and USF funds that are used for those purposes. So this is a delineation of responsibilities for a number of folks so that the broadband office will be a player in broadband and will have sort of primary visionary responsibility, but the Public Service Commission, as the force that does all of the regulations and as the regulatory body, will continue to function in that capacity, especially in those high cost areas, especially with respect to the NUSF, which has, by the way, traditionally been their function.
1 minute.
Thank you, Mr. President. So in the entire history of the Public Service Commission with respect to these telecommunications issues, they have been regulatory. Their body has generally been a regulatory body. They handle things like the carry of last resort. Some of those kinds of questions, which they will continue to do under this bill, under the broadband office, and in the future, because they will retain regulatory authority. So what we're doing here is we are providing one broadband office, not a whole new department, but the office. And when they get that person appointed, who's going to be the BOD, as I like to call them, the Broadband Office Director, that person will function as sort of the visionary, the sort of central sort of person who decides sort of what our direction is, because there's a lot of work that we can do in broadband, and it's going to take some organization and some foresight. Thank you, Mr. President.
Thank you, Senator DeBoer. Senator Conrad, you're recognized to speak. This is your third time.
Thank you, Mr. President. I'm happy to yield time to Senator Blood if she so desires.
Senator Blood, 4 minutes, 55 seconds.
Thank you, Mr. President. I was actually going to sit down, but I'm going to go ahead and take this time. Thank you, Senator Conrad. So what I heard Senator DeBoer say is that the PSC was doing a perfectly fine job. So the question I have again is, why are we taking away responsibilities? And I agree they are the regulatory body when it comes to implementing the things that we need for broadband and when it comes to overseeing what's going on. But I also disagree that by codifying what's already in place, we're doing any types of protections. If indeed we have to codify for that, why are we even giving it to the executive branch? It's very suspect, and I think it's very concerning. It's very concerning that we're willing to give away the transparency that the PSC provides that the executive branch won't be able to provide. And again, our previous governor, not even a year ago, said that all the legislation, all the policy, all the staffing was in place for us to move forward successfully. So we're going to throw the baby out with the bathwater. Now again, I mean, a lot of you have come to me and said, we didn't really like Governor Ricketts. Okay. But here's the thing. That doesn't mean that our current governor can do any better. Because if after 10 years, there have continued to be mistakes, there have continued to be a lack of good broadband available for all Nebraskans, that comes back to us. Comes back to bad legislation where we did a bad job of tracking what was going on, where we didn't have the expectation that we would get more bang for our buck. And it goes way, way back to previous legislative bodies slimming down our choices when it came to who we could choose to do broadband. I disagree with Senator DeBoer, respectfully. We don't need this bill. It's a feel-good bill, but that seems to be a lot of what we're doing this year. I respect that everybody's coming together and hitching rides. I'd be happy if I get any of my bills out of committee this year so I could hitch a ride as well, but I don't have that benefit because I'm not a committee chair and I am obviously not one of the cool kids. So, but that's okay. My mom still loves me, I think. So with that, I would yield any time I have left back to the president. I am hoping that we're ready to vote on this amendment, and I look forward to the other amendments. Thank you, Mr. President.
Thank you, Senator Blood. No one in the queue. Senator Dungan, you're recognized to close on the amendment. Senator Dungan waives closing on AM 1096. The question is the adoption of AM 1096. There's been a request for a call of the House. And the question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Mr. Clerk.
14 ayes, 2 nays to go under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senators Day, DeKay, Jacobson, Kauth, Armendariz, Dover, McDonald, Wayne, please return to the chamber. The House is under call and record your presence. Senators Armendariz and Dover, please return to the chamber. The House is under call. All unexcused members are present. There's been a request for a roll call reverse order vote. The question is the adoption of AM 1096. Mr. Clerk.
Senator Wishart. Voting yes. Senator Wayne. Voting yes. Senator Walls. Voting yes. Senator Von Gellern. Voting yes. Senator Vargas. Voting yes. Senator Slama. Voting yes. Senator Sanders. Voting yes. Senator Reapy. Voting yes. Senator Raybold. Voting yes. Senator Merman. Voting yes. Senator Moser. Voting yes. Senator McKinney. Voting yes. Senator McDonald. Voting yes. Senator Lowe. Voting yes. Senator Lippincott. Voting yes. Senator Linehan. Voting yes. Senator Kauth. Voting yes. Senator Jacobson. Voting yes. Senator Ibach. Voting yes. Senator Hunt. Voting yes. Senator Hughes. Voting yes. Senator Holdcroft. Voting yes. Senator Harden. Voting yes. Senator Hansen. Voting yes. Senator Halloran. Voting yes. Senator Geist. Voting yes. Senator Frederickson. Voting yes. Senator Erdman. Not voting. Senator Dungan. Voting yes. Senator Dover. Voting yes. Senator Dorn. Voting yes. Senator DeKay. Voting yes. Senator DeBoer. Voting yes. Senator Day. Voting yes. Senator Conrad. Voting yes. Senator Clements. Voting yes. Senator Michaela Kavanaugh. Voting yes. Senator John Kavanaugh. Voting yes. Senator Breezy. Voting yes. Senator Brewer. Voting yes. Senator Brandt. Voting yes. Senator Bostelman. Voting yes. Senator Bostar. Voting yes. Senator Blood. Voting yes. Senator Ballard. Voting yes. Senator Armendariz. Voting yes. Senator Arch. Voting yes. Senator Albright. Voting yes. Senator Aguilar. Vote is 47 ayes, no nays, Mr. President.
AM 1096 is adopted. I raise the call. Mr. Clerk, next item.
Mr. President, next amendment from Senator Geist, AM 1142.
Senator Geis, you're recognized to open.
Thank you, Mr. President. I would offer Amendment 1142 to LB 683. This amendment is LB 412 as amended by the Transportation and Telecommunications Committee. LB 412 is currently on general file and was designated as the Transportation and Telecommunications second priority bill for this session. The amendment also contains LB 124, which was introduced by Senator Mosier, a bill that extends the sunset date for the County Bridge Match Program from June 30th, 2023 to June 30th, June 30th, 2029. The additional components of AM 1142 are as follows. The original LB 412, the Broadband Bridge Act, is amended to provide that Federal Capital Projects Fund allocated to the 3rd Congressional District may be allocated to the local exchange service area of any municipality containing a city of the second class or village. Last year, LB 1024 limited the use of such funds in Congressional District 3 to the municipal limits of these cities and villages. The original LB 155 amends the Small Cell Wireless Deployment Act, introduced by Senator DeBoer. The bill clarifies that the act does not apply to the activities of a communication service provider that are outside of the scope of the Small Wireless Facilities Deployment Act. And let's see, in just a moment, I will yield some time to Senator DeBoer to speak about that if she would like. The original LB 359, introduced by Senator Hughes, LB 359 amends the application requirements for the Broadband Bridge Act. Current law states that the applications for grants under the program must be filled with the Public Service Commission on or before July 1st of each year. LB 359 provides that the Public Service Commission shall establish and post on its website the deadline for filing applications for Broadband Bridge Act funding. The final two elements of AM 1142 are LB 122 and LB 722, both of which were introduced by Senator Bostelman. Mr. President, I would yield the remainder of my opening to Senator Bostelman for the explanation of those bills as amended by the Transportation and Telecommunications Committee.
Thank you, Senator Geist. Senator Bostelman, you have 7 minutes, 13 seconds.
Thank you, Mr. President. LB 122 is a one-call bill. AM 1142 contains provisions of my bill, LB 122. This bill is intended to improve the enforcement of violations under Nebraska's one-call system. Our one-call system has two goals. The first goal is to ensure the safety of Nebraska's contractors and citizens to work around underground utilities. The second goal is to protect Nebraska's underground utility infrastructure from damage. To make sure we're meeting both of those goals as best as we can, we need an efficient and effective enforcement system for violations. For those of you new to the body, we've had bills over the last several years, sessions aimed at improving the time between filing of a one-call complaint and time it is resolved. Right now, that time period can be 2 or 3 years if the complaint is resolved at all, and that is far too long. What we have heard is that there are two main problems with our current system that cause these delays. First, there is no staff dedicated to investigating the complaints that are filed. Second, there's no modified process for small first-time violations to be dealt with quickly. A small claims court of sorts. Right now, one attorney in the Attorney General's office dedicates a portion of their time to doing all of the following: receiving complaints, investigating those complaints, and prosecuting those complaints that require it. There is simply not enough bandwidth there for all these things to be done. This bill proposes to fix these issues by having one-call complaints filed with the State Fire Marshal's office, who would also be responsible for investigating complaints. Upon completion of the investigation, the Fire Marshal shall refer their findings to the newly created Underground Excavation Safety Committee, who would determine whether complaints constitute violations. The committee would be made up of the State Fire Marshal or their designee, 3 representatives of operators, 3 representatives of excavators, and alternates in the instance of a conflict of interest. The bill caps the committee's authority to levy fines at $10,000 and also gives them the authority to assess non-monetary penalties like continuing education. The concept in creating this committee and at the same time limiting its authority is to have a small claims type of forum where minor violations can be dealt with quickly. I want to make it clear that those complaints, violations, where the consequences can be severe, where penalties can be more than $10,000, LB 122 keeps the enforcement mechanism the same. Only the Attorney General can prosecute those types of violations in district court, just as they do currently. Finally, the bill also addresses excessive refresh requests. Specifically, it would be a violation of the One Call Act for an excavator to serve notice of their intent to excavate an area in which an excavation cannot be reasonably commenced within 17 calendar days after the excavation start date. Similarly, it is also a violation to request remarking or re-identification for any area in which the excavation cannot be reasonably commenced or continued within 14 days of the remarking or re-identification is complete. I want to thank all the stakeholders who have worked on this amendment. The bill was advanced out of committee with an 8-0 vote. I would ask for a green vote AM 1142 and LB 683 and its advancement to select file. The other bill amendment that I have is LB 722. And LB 722 may take me a little bit longer. Actually, if Senator DeBoer, would you yield to a question?
Senator DeBoer, will you yield to a question?
Happily.
Would you like to tell us about your amendment to the bill?
I would love to tell you about my amendment. My amendment is small cell means small cell. That's the whole bill. Small cell means small cell. The problem is that there was some question about the interpretation of the small cell bill that we passed and whether that bill that we passed would apply to other things besides small cells. But the answer is no, it doesn't. But our clarification simply says small cell means small cell. And when we say small cell, we mean small cell. So this is the small cell means small cell bill. And that's what it is. Small cell means small cell. Thank you, Mr. President.
Thank you, Senator DeBoer. Senator Mosier, would you like to tell us, would you yield to a question? Would you tell us a little bit about your bill?
Senator Mosier, will you yield to a question?
Yes. Or is that the question? That must be the question. My part of the bill is to extend the expiration date of the County Bridge Match Program. It was a program that was fairly popular. It allowed counties to apply for a grant to pay for part of replacing bridges that needed to be rebuilt or made structurally sound. The expiration date is here. The money that we had for this program is pretty much spent already, but this would keep that part of the bill alive. And then in a future bill, we could add more of an appropriation to give the counties more in the way of bridge match repair money. Thank you.
Thank you, Senator Mosier, and I'll yield the rest of my time back to the chair.
Thank you, Senators. Mr. Clerk, for a motion.
Mr. President, priority motion, Senator Michaela Cavanaugh would move to bracket the bill until May 18th.
Senator Michaela Cavanaugh, you're recognized to open on the motion.
Thank you, Mr. President, colleagues. I rise in support of AM 1142, I think. I'll have to look. I think I voted for the bills that are in the amendment. I'm fairly certain I voted for small cell is small cell. It was a controversial one, and I wasn't sure what I was going to do. It was right down to the wire if I was going to vote for it or not. But ultimately, I decided that that clarification was helpful. So thank you, Senator DeBoer. So we had a big announcement over lunch, and when we came back from lunch, and the announcements keep coming. The governor has announced that he will announce the new senator for LB 25 tomorrow. And I am extremely concerned and upset. And Nebraska, you should be upset. I can't remember the last time we had a gubernatorial appointment to a legislative seat without an application first. Purely plucking someone out of his roster and putting them in the seat without even going through the perfunctory motions of saying, the people of District 25, submit your names if you would like to serve. That, Governor Pillen, is disrespectful. It is disrespectful. You could have it open for 5 hours, but at least do the bare minimum. For the people of LD 25, that is so disrespectful. It just reeks of cronyism. You should show us all that you are going to do things differently and do things the right way. You can still have somebody in the seat by Tuesday when we're back in session to vote for whatever's on the agenda on Tuesday that you want so badly. You can still do that and have an application process open today, close it on Saturday, announce on Sunday, swear in on Monday, in the seat on Tuesday. It is possible. But instead, you're going to pluck somebody out and you're going to put them in the seat with zero transparency or effort. It reeks of cronyism. Reeks. I don't know why you would put that kind of stink on the person that you're going to appoint. It's not fair to them, and it's not fair to the people of the district. And it is really inappropriate. And it is really disrespectful. But it brings up a great point. We do not have a process for gubernatorial appointments to the legislature, which makes no sense whatsoever. So I think this is a great opportunity for us as a legislature to focus on that, to focus on it. And we have had a lot of appointments recently. And by recently, I mean since I've been here, we have had a lot of appointments. And as far as I know, everyone that I currently serve with that was appointed at one time or another applied for the appointment. So I don't know why we would do it differently this time, but I do think it warrants a change. Because the people of Nebraska deserve transparency. And it is not transparent if you have it at the whim of the governor as to how something is done. Literally the whim. The governor can choose to do an entirely public application process, an entirely private application process, or as we are seeing today, no application process at the whim, not the will of the people, the whim of the governor. Future colleague, whoever you are, I am sorry that you are going to have that stink on you. From day one, cronyism, so inappropriate. Shouldn't have to be told that, Governor Pillen. Shouldn't have to be told that. Be better than that. Do better than that. Thank you, Mr. President.
Senator Bostelman, you're recognized to speak.
Thank you, Mr. President, and good afternoon, colleagues. I want to talk to you about LB 722. It's the other bill that I have that's in AM 1142. The amendment on LB 722 came about through a months long collaboration of 14 stakeholders listed that all have come together to a consensus on this language. I introduced LB 722 because Nebraska is expected to receive as much as $500 million from the federal government in the next few years for construction and broadband infrastructure. This legislation is critical to making sure the state is prepared for that significant infusion of funding. LB 722 has three primary objectives. First, it ends the present system subsidizing two broadband providers to serve the same area. Second, the bill establishes the regulatory certainty needed to make sure funding is used to reach rural areas. And finally, LB 722 ensures that Nebraska will be positioned to cover the ongoing costs of operating the network we are building. So what's the background? In the past 3 years, Nebraska has awarded roughly $70 million in grants from broadband construction through the CARES Act and Broadband Bridge Program. Nearly $45 million has also been awarded under the Nebraska Universal Service Fund, NUSF, for broadband construction. Some of these funds have been awarded to competitive broadband providers in areas of the state historically served by incumbent telephone companies. In those same areas called exchanges, the incumbent carrier is receiving ongoing support from the NUSF to cover the costs of operating and maintaining their network. The incumbent receiving this NUSF support also has a duty to provide telephone and broadband services to all customers in the exchange. This duty is commonly called the carrier of last resort or COLR obligation. So we have two carriers, the competitor and the incumbent, receiving subsidies in the same areas. One is getting a grant to build, the other is getting NUSF support to operate its network. The amount the incumbent is receiving in ongoing NUSF support is very small compared to the grant the competitor is receiving, yet the incumbent is still expected to carry out their COLR duty. Effectively, by funding the competitor, we are reducing the incumbent's customer base and making it harder for them to serve areas where they receive NUSF support and continue to have COLR duty to serve. In the next few years, Nebraska is expecting infusions of $87 million in capital projects and say approximately $400 million in BEAD funding from the federal government. This significant amount of money has been dedicated to construction of broadband infrastructure. Larger grants will mean larger areas transitioning from incumbents to competitors. The problem of subsidizing both incumbent and competitive providers in the same area will only get worse if we do not address it now. What's the function of the bill? The bill first requires the agency making a broadband deployment grant to collaborate with the PSC and the broadband office in determining project areas. For example, it could also be a county granting ARPA funds for broadband infrastructure. Once a project is completed to the satisfaction of the agency making the grant and final payment is made to the competitive provider, then the bill requires the PSC to relieve the incumbent carrier of any NUSF support it was getting for the project area and the incumbent's carrier of last resort obligations. It is a simple administrative process. The bill then authorizes the commission to make decisions about what to do with NUSF support and COLR duties. In rural and sparsely populated areas, competitive providers will need NUSF support to sustain the network over the long term. If they choose to receive NUSF support, then the provider will have the indefinite COLR responsibility. So what's our objectives? Funding two broadband providers in areas where a business case cannot be made for one does not make sense fiscally. This is a waste and has to stop. LB 722 will help us stop it. By ending the system of dual subsidies, LB 722 will also achieve other beneficial objectives, including providing regulatory certainty where there isn't today. Incumbents and competitors both need certainty. In rural areas where the cost of providing service by necessary exceeds revenues, right now there's no assurance of even indication that the incoming competitor will receive the critical NUSF support they will need to cover the long-term costs of operating and maintaining the new broadband infrastructure. The competitor knows they have to maintain the network, but has no way of knowing if they will ever be able to access NUSF funds designed for the support. This bill gives the PSC clear authority to address these issues. It will be very important for the role of PSC to ensure that we cover the cost of keeping that expensive network running reliably. LB 7022 is technical, but necessary piece of regulatory piece we need to put together in anticipation of the incoming federal funds. With LB 722, we will better position to get all of Nebraska connected and
That's your time,
incentivized.
Senator.
Thank you.
Thank you, Senator Bostoman. Senator DeBoer, you're recognized to speak. Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. So we are on the transportation bill that I oppose, the broadband bill. So in 2017, I announced I was running for office. I started running my campaign. I had campaign kickoff, all the fun things. And then the incumbent I was running against resigned in the fall of 2017. And the election was in the fall of 2018. So there was an appointment. And guess what? There was an appointment process. There was an application. I applied. Now, was I holding my breath waiting for that call from Governor Ricketts that he was going to appoint me? Most certainly not. But I applied because I was running to serve in the office, and I thought that it would be disingenuous to not put my name in for the appointment because I was serious about wanting to represent District 6. So I applied. Submitted my resume and a cover letter. And they are on my personal computer, so I don't have them up right now because it's my work computer. But I sent them through, I think there was just an email contact in the governor's office, but there was a press release about it. There was a deadline. And so I did it. And then I heard from the governor's office. His communications director at the time, I think that was his title, Taylor Gage, contacted me and interviewed me. I will say that It was not what I viewed as probably the right questions to be asking of a gubernatorial appointment to the legislature. But nonetheless, I was asked some questions on specific policies, nothing really about myself as a legislator or policymaker, but what have you. And then, I don't know, maybe 4 or 5 days later, there was a deadline. There was a date where the application closed. And then I believe that Senator Thibodeau hadn't applied yet, and since the governor had not found anyone that they deemed suitable to appoint to the seat, essentially, he reopened the application process so that Senator Thibodeau could apply. She did, then she was appointed. A process. I can't remember how quickly or how long the seat was vacant. I think there was less of an urgency because we weren't in session to fill the appointment. So the process was a little bit longer, or the application process was open a little bit longer, but a process. Process is important. Process is important. Now, maybe I'm wrong. Several of my colleagues have been appointed, and maybe I am missing some information here, but I believe that there was an application process, that there was a press release put out saying, if people wish to serve this vacated seat, please apply. That's not what's happening today. And everyone should be upset about that. It's inappropriate. It's inappropriate. And it is disrespectful to the people of LD 25. Disrespectful. So, on my next time, I will probably get back to the bill, but I don't know. Maybe I'll talk about this a little bit more. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Bostelman, you're recognized to speak.
Thank you, Mr. President. I wanted to try to finish up what the rest of the opening on my on the amendment to 412 LB 722. Let's go back to the objectives. What the objectives of the bill is: funding of 2 broadband providers in areas where a business case cannot be made for one does not make sense fiscally. So that's what LB 722 will help us to stop. By ending the system of dual subsidies, LB 722 will also achieve other beneficial objectives, including providing regulatory certainty where there isn't today. Incumbents and competitors both need certainty. In rural areas where the cost of providing service by necessity exceeds revenues, right now there is no assurance or even indication that the incoming competitor will receive the critical NUSF support they will need to cover the long-term costs of operating and maintaining the new broadband infrastructure. The competitor knows they will have to maintain the network, but has no way of knowing if they'll ever be able to access NUSF funds designed for this support. LB 722 gives the PSC clear authority to address these issues. It will be the very important role of the PSC to ensure that we cover the costs of keeping that expensive network running reliably. LB 722 is a technical but necessary piece of the regulatory puzzle we need to put together in anticipation of the incoming federal funds. With LB 722, we'll be better positioned to get all Nebraska connected and incentivize new broadband build out in rural areas that need it the most. I would like to thank all the stakeholders who, through a months-long collaboration, worked on putting this amendment together. I sincerely want to thank them because it was a long process and it was very open and good dialogue. This bill, as amended, was advanced from committee with an 8-0 vote. I urge you to join me in supporting this much-needed legislation with a green vote on AM 1142 and LB 683 on its advancement to final reading. One thing I guess I'll add to this is, so you may ask, what are we talking about? So here's an example. Let me give you a short example of how LB 722 will work. Out in the Panhandle, Lumen is responsible for territory that was deemed unserved. A smaller company by the name of Mobius received a grant from the PSC to build fiber to the home inside Lumen's territory. However, Lumen is still receiving NUSF support and still has Kohler duties. What LB 722 establishes is a clear process for NUSF funds to be transferred to Mobius in order to help them maintain their network. With this support, Mobius is able to take on the Kohler duties while Lumen is relieved of its duty to serve customers it is no longer able to serve. The Public Service Commission would be responsible for overseeing this transition. With that, Mr. President, again, I urge everyone a green vote on AM 1142 and underlying bill LB 683. Thank you.
Thank you, Senator Bostoman. Senator Michaela Cavanaugh, you're recognized to speak, and this is your last time before your close.
Thank you, Mr. President. Okay, so AM 1142 is another committee priority. Would Senator Bosselman yield to a question?
Senator Bostoman, will you yield to a question?
Yes.
It's a friendly question.
Yes, I will.
Your bill that's in this committee package, remind me, I know it was kind of a monumental feat. What was the bill number, first of all?
122, the one with one call, or 722, the one I just spoke about? Well, one call with diggers or?
722. Okay, that was the bill number.
722, the one I just spoke about with broadband?
Yes.
It was. It's a national type of a first. When I said the 14 collaborators with this, we actually had lawyers representing the companies. There were national attorneys involved with it. So it was a very big effort to get done. And, those who cooperated and worked together, it's a pretty big deal.
How many years have you been on this committee?
Sorry?
How many years have you been on this committee?
7 now.
Wow. This is a big deal. I remember when we voted, now I'm remembering when we voted on the package, and I remember when we voted on your amendment into the package.
Mm-hmm.
And again, like the small cell, I didn't know what I was going to do. It was a real game day decision. But I voted for it, right?
Yes, you did.
All right.
I think you may have even advanced it. I'm not sure.
What? That doesn't sound like me. All right. Well, thank you, Senator Bosselman. It is a big deal. And now that I have been refreshed on what 1142 is, I know that I am ultimately going to vote for the amendment because it did a lot of things that we as a committee had worked on for a long time. And I am actually very lucky with my committee assignments. I really enjoy serving on the HHS committee with my colleagues on the committee, and I really enjoy serving on the transportation committee with my colleagues on that committee. And HHS is, sometimes I say it's a bit of a slog. It is a hard committee to sit on. We have some very hard hearings, testimony. I'm sure if there were a bingo game going with the number of times I've cried in that committee, everyone's card would be filled. It is very hard, but I very much enjoy serving on that committee with my colleagues, Senators Hansen and Reapy and Ballard and Walls and Day and Hardin, and we do have a nice time. I also enjoy serving on the Transportation Committee. We deal with some pretty dry stuff sometimes. I remember my very first hearing on transportation, my first year. when the director of the department came in and was talking to us, this is legit, was talking to us about different grades of concrete. And I was like, what am I doing? How did I end up here?
1 minute.
Not sure that I could have less of a technical interest in different grades of concrete. Turns out I am interested about different types of concrete and the thickness of it. You want really thick concrete for your airports. Want to make sure you got that extra thick concrete for when you got heavy things going on them. So it turned out to be an interesting road, but this particular amendment and this particular package is a culmination of a lot of years of work in the Transportation Committee. And Senator Bostelman, by the time that he is done here, will have served on that committee for the entirety of his time here. And so this is a real wealth of knowledge and information. And it's built upon other things. The one call bill that we were just discussing it's built upon the work of a previous one call bill.
That's your time, Senator, and you're recognized to close.
Thank you, Mr. President. It's built upon a previous one call bill that we had in the committee in the last biennium that Senator DeBoer had introduced. And so everything that we have done is building upon the work that we as a committee have done. So I just wanted to note that because I very much appreciate my colleagues on the Transportation Committee and, of course, our committee counsel who I just saw walking up front. I think he really is the breadth of the knowledge there for most of us. We rely upon our committee counsel on TNT very heavily. So, and grateful that he came back to the legislature to serve as our committee counsel, because he certainly could have been doing something way more relaxing with his life at this point. But so thank you to Mike Hibble for that. Okay, so we're going to vote on the bracket motion for May 18th, 2023. Some people might call it a rehearsal for May 19th, but May 19th is not a day we are in session, so May 18th, 2023. I mean, I suggest you vote against the bracket motion, but not against the spirit of the date. Okay, so I would like a call of the House with a machine vote. Thank you.
Thank you, Senator Kavanaugh. There's been a request to place the House under the call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Mr. Clerk?
10 ayes, 1 nay to go under call, Mr. President.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senators Conrad, McDonald, and please return to the chamber and record your presence. The House is under call. All unexcused members are present. The question is the motion to bracket. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
Zero ayes, 44 nays, Mr. President, on the motion to bracket.
The bracket motion fails. I raise the call. Mr. Clerk, for a motion.
Priority motion, Senator Michaela Cavanaugh would move to reconsider the vote just taken on MO 915, on 912.
Senator Michaela Cavanaugh, you're recognized to open.
Thank you, Mr. President, colleagues. Okay, so motion to reconsider the vote to bracket. And I'm just going to go back to the draft Nebraska Strategic Broadband Plan. Grab my pen. Okay, so let's see here. Where did I leave off? So there's where I left off on page 5. So the broadband plan, this is what I was reading. And as I was reading it, I was also editing it. So I will continue doing that. So I'm on the conclusion at the bottom of page 5. The historical funding available through the federal government has resulted in opportunities to accomplish the goals in the Nebraska Strategic Broadband Plan and bridge the digital divide. The Broadband Office is uniquely positioned to successfully leverage resources where they are needed most in Nebraska. Accelerating broadband will ensure Nebraska's economic recovery, improve resiliency, help communities thrive, and ensure that everyone has access to essential activities and services needed for a better quality of life. They used the Oxford comma. Just going to point that out. I guess I didn't read all of the grammatical things. So the next subheading, roadmap to connect 99% by 2027 table. The Nebraska Strategic Broadband Plan will connect 99% of Nebraska. My phone is ringing. I'm talking on the floor, whoever's calling me. It's an unknown Lincoln number. Roadmap to connect 99% by 2027. The Nebraska Strategic Broadband Plan will connect 99% of Nebraskans to high-speed internet by 2027. That is an ambitious goal in 4 years. The following table is a projection of the percentage of residents that the Broadband Office proposes to connect through 2027. Included is the percent of funding that will be utilized per federal programs each year. The success of connecting residents to broadband by the projected date is based on variables that the Broadband Office does not influence. Okay. The broadband now someone within the chamber is calling me. It's like like a horror film. The call's coming from inside the chamber. I am reading slowly, so I am taking that feedback. I know you want me to read faster, but I'm reading slower. I'm not going to do what you want, Senator. I'm not going to do what you want. I'm going to read slow. Okay, so projections are subject to the following variables. Completion of Nebraska mapping by the FCC, completion of the challenge process by the FCC, the total amount allocated by the NTIA for BEAD, the time of funding allocations made available by the NTIA for BEAD, grant awards to subrecipients to the NTIA for middle mile, labor and supply chain delays, local permitting, easement, and right-of-way delays, market dynamics that impact the drivers of adoption, complete applications by subrecipients, state procurement and contracting process, completion and closeout of construction for broadband projects, compliance and monitoring of subrecipients. Connectivity and funding utilization percentage table. Okay, so we have, it's a table. And honestly, after last night, I'm just too tired to read the table. Okay, I'll read the table. Challenge accepted, Senator Kavanaugh. Read the table. By the way, I just challenged myself in my head. That wasn't, anyways. Connectivity and funding utilization percentage table. And I'm also going to take the feedback to read faster. Percent of households connected, 2023, 86.7%, 2024, 89%, 2025, 93%, 2026, 95%, 2027, 99%, total 99%. Federal and state program utilization, E-rate, don't know what that means, 20% in 2023, 20% in 2024, 20% in 2025, 20% in 2026, 20% in 2027, 100% total. Bridge with 2 asterisks, look down below. Bridge is a state-funded program administered by the Nebraska Public Service Commission and is an ongoing program. Bridge, 20% 2023, 20% 2024, 20% 2025, 20% 2026, 20% 2027, 100% total. CPF, don't know what that is. 50% 2023, 50% 2024, 0% 2025, 0% 2026, 0% 2027, 100% total. DE, again, don't know what that is. 53% 2023, 47% 2024, 0% 25, 0% 26, 0% 27, 100%. BEAD, the program at hand that we are talking about. 0% 2023, 25% 2024, 50% 2025, 25% 2026, 0% 2027, 100% total. EMM, don't know what that is. 0% 2023, 20% 2024, 40% 2025, 40% 2026, 0% 2027, 100% total. Up at the top, 2027 has 3 asterisks. Down below it says all federal programs are required to be executed by 2027. Okay. Oh, and projections are based on predictions and based on variables that the broadband office does not influence. The table is based on the drawdown of funds. The internet gap is defined as residents who do not receive at least 100 over 20 Mbps. Broadband, we talk a lot about broadband speeds on TNT, and sometimes I lose track of what we're even talking about with broadband speeds, but there you have it. Broadband goals and actions to accomplish the strategies identified in the Nebraska Strategic Broadband Plan. The Broadband Office has developed a list of goals and actions needed to implement the plan over the next several years. Since the state's broadband plan is a newer initiative, revisiting and refining the implementation plan will be necessary. Incremental evaluation is included and required to benchmark success against different strategies, and report regularly to stakeholders on progress to ensure transparency. Goal 1, in bold, bolster economic opportunity by connecting 99% of residents, particularly those in growing rural communities, to high-speed internet by 2027. Universal, this is now the text underneath. It is not in bold. Universal access to broadband and developing networks that are future-proof require being technologically agnostic and focusing on performance. The state's broadband program gives preference to symmetrical speeds of 100 over 100 or higher. The grant program design will be conservative and competitive as Nebraska is a high-cost state, and criteria will include incentives for investment in areas of critical need. Projects will include both last and middle mile infrastructure and a mix of fiber and alternative technologies. Okay, gonna pause. Grammatical thing here. Projects will include both last and middle mile. Nope, never mind. Moving on. Funding sources to achieve goal. Funding source.
1 minute.
BEAD, check mark, 24 to timeframe 2024 to 2026. DE, check mark, 2023, 2024. EMM, check mark, 2024 to 2026. CPF, check mark, 2023 to 2024. Bridge, check mark, 2023 to 2027. I think I am almost out, so next I will be on strategy 1.1 : and that is where we will go on my next time on the mic, which I am next in the mic. So, thank you, Mr. President.
Thank you, Senator Kavanaugh, and you are next in the queue.
Thank you, Mr. President. Strategy 1.1: prioritize fiber deployment. Target funding in areas where a negative business case for investment for the unserved and underserved exists. Consider greenfield deployment to reduce the cost of investment and increase competition. Before I continue on, when we were on this bill, whenever that was, I think it was last week, I had a question about greenfield deployment, what that meant, and my colleague on the committee, Senator Tom Brandt, came over and explained it to me. So thank you for that, Senator Tom Brandt. I'm going to attempt to share that explanation with those who are following along. So greenfield deployment is pretty much what it sounds like, a green field, a space that is unused. It is green for development. So did I get that right? I got a thumbs up. I got it right. Awesome. Okay, so activities. These are all bullet points. Okay, activities. Provide fiber to as many unserved locations as possible. Order in priority from highest to lowest cost to serve. Provide alternative technology to every other location. Next bullet, increase where there is a negative or alleviating business case for the unserved. Match requirements for subrecipients need to provide an incentive for investment. Next bullet, require a competitive match for subrecipients where there is a positive business case for investment by the private sector. Match requirements will be part of the grant program application process that will be made available in 2023. Okay, next bullet, design a grant program that encourages brownfield build-outs that bring down costs by upgrading existing infrastructure. I'm going to need to know what brownfield developments are, but I'm guessing that there's something like sort of used that haven't quite been built out. I'm like doing a whole pantomime here from across the room. Okay, I think I might be on the right track with that. I will get clarification at another date and time and bring it back to you all at home. Okay, brownfield, lost my place. Program, brownfield build up. Okay, next bullet. The state will provide a subsidy for at least 15% of capital expenditures by weighing non-financial considerations in the award process and where there is a lack of competition. Next bullet, invest in community anchor institutions, CAI, to ensure reliable high-speed access or identify opportunities in non-traditional CAIs. Next bullet, the CBO, don't know what that is, will monitor the design, engineering, site prep, construction, closeout, and performance of the last and middle mile projects to ensure that investments are built on time. They use the Oxford comma. Performance metrics, bullet point, increase in broadband access minimum 100 over 100 for rural households from 86.7% to 99%. Really gonna suck to be in that 1% in 2027. Like everyone else in the whole state is gonna have broadband, but 1%. But we'll get you there someday. I just hope that it isn't Senator Bosselman's house. Too soon? Possibly. Next bullet. Number of households served with minimum speed standards of reliable 100 Mbps. Symmetrical upload and download unless geographically, topographically, or excessive cost than 100 over 20 and scalable to 100 over 100. Next bullet, number of homes on tribal lands being connected to broadband speeds of 100 over 100 Mbps. Strategy 1.2, set a high cost per location threshold, which balances funding the use of fiber and alternative technologies to expand coverage for harder to serve areas. Activities, bullet point, designate high-cost areas in Nebraska that consider poverty levels, rural locations, and race and ethnicity to target funding. Next bullet, set a cost per location threshold for the unserved. Next bullet, incorporate brownfield development costs per location when feasible to reduce costs. Performance metrics, bullet, number of unserved and underserved connected to high-speed internet. I think I'm about done. I'm going to grab a lozenge before he says my next turn. Thank you.
Thank you, Senator Kavanaugh, and you're next in the queue.
Ha, I did it. Okay. Strategy, 1.3, utilize location level mapping and analytics to assess areas of critical need and to target areas that require subsidies. Activities, bullet, develop serviceable location data mapping capabilities that reflect real-time speed, test latency, and current technologies. Again, consistently using the Oxford comma. Next bullet, create a funding dashboard that identifies areas of critical need, current and proposed investments. Oh, didn't use the Oxford comma. Wondering, I'm going to have to think on that one a little bit more, if it even would warrant or be appropriate to use the Oxford comma. But neither here nor there. Next bullet, Create a broadband projects dashboard to inform stakeholders where investments are occurring in the state. Next bullet, number of speed tests confirmed. Next bullet, percent increase in confirmed reported service speeds. Goal 2, expand digital inclusion and adoption to achieve affordability, access, and digital literacy by 2025, by 20% by 2027. Use of Oxford comma. NTIA attributes adoption gaps in digital equity to affordable access to service, access to internet-enabled devices, and digital literacy. See, now this one I know they are not consistently. Oxford comma was not used there. Could have been. So just for consistency's sake, going to point out when we have it or we don't have it. We want to be consistent in our style of writing. Connecting 99% of households to high-speed internet access requires investment in digital equity. The Nebraska Strategic Broadband Plan includes strategies to support digital equity. Funding sources to achieve goal. All right. So this should go over to the next page because it has the top of the chart on one page and then the data on the next page. So that is not an easy way to read a chart. Okay, next page. And then chart top here. Sorry, if I am going to be reading this and it is a draft and it very clearly says draft on it, I figure I may as well give it back to the department when I'm done since I'm editing it as I go along. Okay, funding sources to achieve goal. Funding source, BEAD, checkmark 24-26, time frame is 2024 to 2026. DE, checkmark 2023 to 2024. EMM, N/A, N/A, CPF, N/A, N/A, Bridge, N/A, N/A. Strategy 2.1, conduct a landscape analysis of existing digital equity and affordability programs and develop strategies to address any gaps. Activities, bullet point, bullet point. Develop a statewide digital equity plan in partnership with the Office of the CIO. Bullet point, increase affordability connectivity program, ACP. Uptake through outreach, education, support, and incentivized participation among eligible subscribers. Again, no Oxford comma. So just a question mark if it should be there. Performance metrics, number of residents participating in the statewide digital equity plan. Strategy 2.2, conduct digital navigator.
1 minute.
Thank you. Is this my last time?
Yes, and you're closed.
Thank you, Mr. President. Strategy 2.2, conduct digital navigator pilots within targeted populations, evaluate strategies that work, and leverage public-private partnerships to build skills and confidence in the use of technologies, period. Activities, I think that that's probably just about my time. So I will pick up at activities on my close. Thank you, Mr. President.
Thank you. Thank you, Senator Kavanaugh. Senator DeBoer, you're recognized to speak.
Thank you, Mr. President. Colleagues, I did want to take a moment to talk about how incredibly important and sort of monumental this bill is. There are a number of different bills that are within this amendment. Senator Bosselman has done an excellent job with his Kohler amendment here, but I would like to talk for a minute about what we call the one call portion of the bill. And I know Senator Bosselman explained it, that you set up a sort of a small claims court for, or what we sometimes call a hit court for these smaller hits. But I do want to take a moment to talk about the importance of this to Nebraska. First of all, because, you know, people across Nebraska, it's very important for us all to recognize that there are lots of underground facilities, and when you dig, you should always call 811 first. 811 is the number that you call, and then you can find out if there is telephone wire or electricity or whatever, cable, whatever in the ground already where you would like to dig. Why is this important? Because if you don't do it, you can actually, like, we have situations where people will dig in the ground. They haven't properly had these locations found, and there can be explosions. There can be all sorts of disruptions of service. I mean, very dire consequences. And we don't want anyone to die, right? So 811 before you dig, public service announcement, everyone 811 before you dig. Why then is this bill important? Because right now, the smaller hits, we call them, where you hit some of these underground facilities, they aren't really being prosecuted isn't quite the right word, but they aren't being followed up on in any sort of official way. And, that is a disincentive to get the locating right, which, we have a lot of very good locators in Nebraska. And also to make sure that every time you dig, that there has been a location done first. And this is important. So how do we make sure that we get that done? Well, part of it is we have some way to redress a loss as a result of either a mislocation, which I'm sure does not happen very often, or a lack of location. So this is why we set up this sort of small claims, we're sort of colloquially calling it, court to look at these things. The big issues are still within the Attorney General's purview. The Attorney General would handle those. But this is just to sort of adjudicate these smaller hits that, maybe it causes a little bit of damage. Maybe it's some sort of disruption of service, but nothing extraordinary in terms of monetary damages. So what we're trying to do is set up some good government here. And Senator Bosselman has done a fantastic job setting this up. You may not know it if you're not in the Transportation and Telecommunications Committee. This is my 5th year on the T&T Committee and my fifth one-call bill. These bills come every year because we've been trying to figure out what is the solution, because we want to protect Nebraskans and we want to do it in a way that makes sense. And Senator Bosselman has done it. So I think, when we figure these things out after a long time and we work them through the committee process and we keep trying and we keep working on them, and finally we come up with a bill that everyone's like, oh yeah, this is the solution. This is the way we're gonna make this work.
1 minute.
I think this is really kind of a remarkable thing, and this is what the legislature is supposed to be for. And this is why our process is hard. If we had just pushed through a bill in the first year, we wouldn't have gotten to the place where we are now, where we have a very reasonable solution, where we have a good solution to the problem that everyone kind of says, yeah, this is probably the right way to do it. So I want to commend Senator Bosselman for getting us through this legislative process, for getting here, and Senator Geist for chairing the committee that got it done. And this has been a long time coming. And I think we should be proud of ourselves as a body today, assuming we can pass this amendment and we can pass this bill and get this done and get it on its way, because solving this one-call problem makes Nebraska safer. It was a difficult problem and it went through our process and it took a long time. And now we have a solution that looks like it's going to work. Thank you, Mr. President.
Thank you, Senator. Senator John Kavanaugh, you are recognized to speak.
Thank you, Mr. President. So I think rise in opposition to the reconsider and in support of AM 1142. I appreciate Senator DeBoer's comments and the work everybody in the committee has done in the Transportation Committee. I don't usually talk on transportation issues, transportation telecommunication issues. In my time, my now 3 years here, I think I've been in front of that committee maybe 3 times, and 2 of them have been on the same issue, and that was the one I wanted to talk about, which is cell phone towers. So I brought bill this year and last year to the Telecommunications Transportation Committee that has to do with the siting of small cell phone towers. And I think it's kind of relevant to the conversation we've been having, because the underlying bill, LB 683, is an attempt to move more quickly in our implementation of broadband and creating a new office and streamlining and those things. And people have issues with that for a number of reasons. But the reason I got involved in telecommunications issues was specifically because of streamlining in the process. So a few years before I got here, this body passed a bill that would streamline the process for installation of small cell phone towers, which are those smaller ones for 5G, and you need more of them than regular cell phone towers. And when this body passed that bill, it made it municipalities have less authority to object to the siting of cell phone towers if the communications company was of the opinion that their site maps said that they had to place a tower in that area. And so the cities felt like they couldn't object to those. And then there was a shot clock put on it, meaning that you had about basically 90 days to respond. So in that context, in that environment where cities felt like they didn't have any ability to reject these applications, they had 90 days to approve them. In one particular instance in my district, in the city of Omaha approved the siting of a cell phone tower that was placed in the middle of a sidewalk. And they dug up just one square panel of the sidewalk, put a cell phone tower in there, and there's pictures. And so I pulled up the story, and this one's from WWT.com, the Channel 6 NBC News in Omaha, from let's see, the date here is July 23rd, 2021. And it says cell phone tower built in the middle of a sidewalk upsets Omaha neighborhood. And they have pictures and video and all this stuff, and you can see what it looks like. But I would certainly encourage you to take a look at that and see. And this is the result of haste, of trying to get things done as fast as possible, and not ill intention, mind you, because these cell phone towers, everybody wants 5G deployed. They want to make sure we have a broad enough deployment of these towers so that people can actually use 5G sooner, and we don't want to create an undue burden to place them there. But because of the way that we structured that expediency, they put a cell phone tower right in the middle of a sidewalk in this person's yard. And then the city ultimately had to go back, and they had thought they were going to put the sidewalk around on the street side, but that didn't comply with the Americans with Disabilities Act. So then they had to put the sidewalk about 5 feet into this woman's yard to go around the cell phone tower. And all of that was because they basically acted too quickly. So I brought a bill, which I think is LB 134. It's still in the Transportation Committee this year. And what that bill does is require that cities have a written plan for how any cell phone tower placement that is going to move a sidewalk complies with the Americans with Disabilities Act before they do it.
1 minute.
So thank you, Mr. President. So they'll still be able to do this. They still would have been able to put this tower on this corner. They just would have had to say ahead of time how it would have complied with Americans with Disabilities Act. Simple fix, a little bit of just slow down the process just when you're going to move a sidewalk, and do that. There's also a notice requirement that the city of Omaha was looking for in that bill. But the heart of the bill is that requirement that these plans, we put down in writing how it's going to comply with Americans with Disabilities Act. Because when you do that, you do have to comply with Americans with Disabilities Act anyway. So we're just saying, make sure you do it ahead of time so we don't go through this process where we dig up a sidewalk and don't know how we're going to make sure that somebody can get down the street. So we need to be thoughtful and respectful of those processes, and sometimes just taking your time, just a little bit of extra step to go through the process and make sure we're not rushing to get things done. And that would solve all the problems. So thanks for listening to my story about the cell phone tower in my district. Thank you, Mr. President.
Senator Lowe, you're recognized.
Thank you, Mr. President. As one who doesn't use broadband very much at my house because I don't have it, matter of fact, I don't have cell service at my house. I call it utopia. It's kind of nice. It's quiet out there. But I'm in support of LB 683 and AM 1142 against motion 912 and 915. Well, I was going through some of my pictures yesterday, and I came across one with 16 people in that. And there was Tom Breesy and Lynn Walls and Anna Wishart, Joni Albright, Mike McDonald, Suzanne Geist, Carol Blood, Steve Erdman, Luann Linehan, Tom Brewer, Steve Erdman, Mike Hilgers, and that was our senior class. And one by one, we're leaving. And it's hard to see those people to go, especially hard to see the one that's going to be leaving at the end of this week. But I talked to a senator who used to be Speaker of the Nebraska Legislature. He said he moved on after session, got out, and he never got to say goodbye. He says he still regrets that to this day. He wasn't able to say goodbye to his friends and his family, because we become a family down here, whether we agree with each other or not. So we're pretty much a typical family. So I appreciate that Senator Geist is leaving us when we can all say goodbye to her, when we can all listen to the story and wish her well in this new endeavor to run the city of Lincoln. It's kind of nice to have friends and family around you when you make a decision, and especially if they support you. So, Suzanne, we wish you well, and we hope and pray that you will have a successful life from here on out. And even more so, we hope that Mark can put up with whatever you bring him. So with that, thank you, Mr. President.
See no one left in the queue. Yeah. Senator Michaela Cavanaugh, you're recognized to close on your reconsideration motion.
Thank you, Mr. President, colleagues. Well, I am on page 9 of a 13-page report. And as much as I want to continue editing this publicly for grammar and the Oxford comma mostly, I am going to withdraw my motions, and hopefully we can get to the next bill on the agenda, because I am very supportive and excited about the next bill. So I will be continuing to be in opposition to this, but I withdraw my motion. Thank you, Mr. President.
Without objection, so moved.
Mr. President, Senator Bostar would move to amend Senator Geist's AM 1142 with AM 1181.
Senator Bostar, you are welcome to open on 1181.
Thank you, Mr. President. So AM 1181 amends AM 1142, which amends LB 683. My particular amendment, 1181, contains LB 63, which is my personal priority bill. LB 63 is legislation that would prohibit a telecommunications company from receiving support from the Nebraska Universal Service Fund or from the Broadband Bridge Act if said company is using or providing any communications equipment or service deemed to pose a threat to national security, according to the Public Safety and Homeland Security Bureau of the Federal Communications Commission. Additionally, LB 63 incentivizes the removal of prohibited equipment by stipulating that any telecommunications company that removes, discontinues, or replaces any communications equipment or services identified as posing a threat to national security shall not be required to obtain any additional permits or authorization from any state agency or political subdivision in the removal, discontinuance, or replacement with like products, which is of similar or less weight and size of such communications equipment or service. So, a couple other points I'll make before I talk about sort of how we got here. Additionally, in the bill, there is a certification requirement for telecommunications companies where annually they would certify that they are not utilizing equipment that has been deemed to pose a risk or threat to national security. And all of the provisions that I've identified would take effect January 1, 2025. The initial green copy of this bill contained the USF funding prohibition, so restricting the access to USF funds, and it included the rip and replace language, so removing the barriers, the sort of red tape barriers that exist that make it difficult sometimes for telecommunications service providers to replace equipment. So those provisions were in the green copy, as well as a 2025 start date. The Transportation and Telecommunications Committee advanced the bill, LB 63, with 7 yes votes and 1 absent member, and included in the committee amendments adopted by the committee a couple of provisions, which include the Broadband Bridge Act funding prohibition and the annual certification requirement provision. As well, the committee amendment included an E-clause on the bill. So instead of the legislation taking effect in 2025, legislation would have taken effect immediately. This version essentially contains all of the provisions that the committee pushed out with the bill in their committee amendment, with the exception that it does not include the E-clause. It maintains the original January 1, 2025 implementation date. With that, I know that we are going to have a discussion about this legislation. So I think for the purpose of time and utilizing the last bit of time we have here today effectively, I'll end my open there, and I'll be ready for questions and responses. Thank you, Mr. President.
Senator Blood, you are recognized.
Thank you, Mr. President. Fellow senators, friends all, I did have a brief discussion with Senator Bostar, and it was the first discussion we've had on this bill. And he brought up some concerns that I have been trying to research, but I'm going to go ahead and put out my concerns, hoping that he can write these concerns down and maybe answer the questions that I have when he speaks next on the mic. So where I'm coming from right now, and I hate to sound like a broken record today, but I don't understand why we need this bill. I have had a bill in the past in reference to terrorism that pertained to things like utilities. I do believe it's an issue and we should have things in state statute. But on February 22nd, our Governor Pillen issued an executive order number 23-05, which I'm handing around if they get the copies made here shortly. Executive Order 23-05 prohibits the state of Nebraska from awarding any grant funding designated for broadband deployment to any provider using or deploying communications equipment and services developed by organizations on the FCC commission that's redundant, on the FCC covered list. The order also directed the state broadband office to maintain, publish, and update a list of all such designated equipment and services on the covered list. So the question that I have is, what does this bill do that's different than what the governor has done? If nothing, then we need not to do this law. If it does more than what the governor has done, then, and again, not a lawyer, but I don't think this bill is constitutional. The Nebraska Constitution blocks any branch of government from exercising another branch's powers. The purpose of the separation of powers doctrine is to preserve the independence of each of the 3 branches of government in their own, or on their own, thus tending to prevent God, there's a word that I can't even pronounce. Basically, why are we skipping over the other branches of government? And that's in our Constitution, Article 2, if you want to look at it. So was the governor acting outside of his authority by issuing that order? Is that what we're saying when we push this legislation forward? And I'm not sure. I do ask that Senator Bostar yield to a question. I'm going to have more questions, but I think he knows the answer to this one.
Senator Bostar, will you yield?
Of course.
So how many companies are impacted by this proposal, to your knowledge?
It appears that in the state of Nebraska, one company is. However, there's a limited amount of confidence that I can use to assert that.
Okay, I appreciate that, Senator. And that's what I remember from the hearing is that to me, it seems like, and it may not be your intent, but from the outside, the optics to me looks like you're targeting a single company. Thank you. That was the question that I had for you. So the federal government has already prohibited this practice. So no other companies can access these prohibited components. So I'm hoping I think I'm going to try and get Senator John Kavanaugh on the mic here in a little bit because this is beyond my pay grade. But I think this is special legislation. Since there are no other companies, it's a closed class then. So a legislative act constitutes special legislation within the meaning of constitutional prohibition of special legislation if, one, it acts and it creates an arbitrary and unreasonable method of classification, or two, it creates a permanently closed class. So that was in our Constitution. I found that under Article 3. So when the legislature, when this body confers privileges on a class arbitrarily, selected from many who are standing in the same relation to those privileges without reasonable distinction or substantial difference, then the statute in questions resulted in the kind of improper discrimination that we prohibit in our own state constitutions by providing this special legislation. So that's the separation of powers, the special legislation. Those are my number 1 and 2 concerns, but I have more concerns that I have written out that I'm hoping to get answered today. Thank you, Mr. President.
Senator Michaela Kavanaugh, you're recognized to speak.
Thank you, Mr. President. I do not support AM 1181. I do appreciate that Senator Bostar did change the date for enactment, so it does alleviate some of that, pushing back the date. But I do think that the federal government has this well in hand, and I'm not really comfortable with the changes to the USF funds. That said, I really want to get to the next bill, so I am going to state my opposition and move forward. Thank you, Mr. President.
Senator Linehan, you are recognized to speak.
Thank you, Mr. President. I rise to support AM 1181 and Senator Bostar's efforts in this. I know he works with Congressman Flood on this. I think this is a very important issue, and I appreciate all their efforts on this. And with that, I would yield the rest of my time to Senator Bostar so he could answer the questions I think he got from Senator Blood. Thank you.
Senator Bostar, 4 minutes 30.
Thank you, Senator Linehan, Mr. President. Senator Blood, I appreciate the questions and having the opportunity to address them. So the governor's EO is restricted to the powers that the governor has. So the governor can prohibit grant funds going to telecommunications providers that have this compromised equipment as it relates to the grant funds that he has and his office have the authority to direct. That does not include the Nebraska USF, which is statutorily established, is distributed by the PSC. And so even with the governor's executive order, any telecommunications company meeting the criteria within 1181 would still be able to receive Nebraska USF funds. This legislation would prevent that. So, you know, that kind of brings me into the separation of powers issue. These are different powers. We have the ability to do this. The governor has the ability to manage and regulate the executive branch's discretionary grants within their related departments. So I don't see that as an issue at all. Targeting one company, special legislation. First of all, we're not sure with certainty that this is about a singular company. There could be more in Nebraska that are subject to these provisions. Also, the legislation doesn't say XYZ company is prohibited from accessing support under the Nebraska USF, the Broadband Bridge Act, or anything like that. It simply says per a federally defined set of equipment that are known to compromise the safety and security of Nebraskans, any company utilizing such equipment would be prohibited from those funds. That is frankly an open class. So I disagree with that point. The feds have prohibited this already. That's not true. So the federal government has a universal service fund, just like Nebraska has a universal service fund. Those are different funds. So the federal government has put prohibitions on accessing universal service fund federal dollars related to equipment that is compromised and poses a risk to national security. We would be doing that with ours. These are separate pots of money. Both are useful at restricting.
1 minute.
So with that, I'll leave that there. Hopefully, at least at a top level, I address some of the questions. We could certainly continue the conversation and dive into more details. But hopefully that was helpful. And thank you.
Senator Geist, you are recognized to speak.
Thank you, Mr. President. I was just going to briefly stand in approval of AM 1181. This is a good bill. It's good in the sense of national security. It's serious. It's something we need to consider, and I just wanted to give Senator Bostar my support. He brought this bill to the committee. I believe it came out of committee all in favor, and there was one absent. But I just wanted to give Senator Bostar my support for this amendment as the chair, and ask the body to support it as well. Thank you, Mr. President.
Senator Blood, you are recognized.
Thank you, Mr. President. Fellow senators, friends all, I actually agree with Senator Geist that national security is very important, but I'm not sure what that has to do with the way this bill is written. I stand opposed to AM 1181, and I'm going to continue talking on it, and I'm going to respond to some of the things that I just heard. So if it doesn't name the company in the bill, the thing that's really weird is that it's very narrowly described in a way that it can only be one company. And if that is indeed the case, then I go back to the point that it's a closed class and this is special legislation. And the question I would have is, did we have anybody with a legal brain look at this? Did we talk to the AG? What did the committee council say about it? I think that I'm not sure what our legal authority really is on this bill. And I think we do need to request an AG's, kind of the theme of the day, an AG's opinion, because I'm not sure if any of our legal experts have really looked at this. What did committee counsel have to say about this particular bill? I understand why people support it. The same reason that we support our veterans bills and our military bills. We don't ever want to be the people that say we're not in favor of something like this. But that doesn't make every bill a good bill. The intent, maybe, I'm starting to wonder, was this like what the press conference was at when Senator Bostar and maybe Senator Geist, or was another senator, and Senator Flood were out in the rotunda, and Flood were out in the rotunda, and they were talking about security and I think China or something. I'm wondering if that was, I didn't stay and listen, but I remember reading about it the next day in the paper. So the advantage of the executive order that I passed around is that the governor can do one in a minute. Like if he doesn't like something, he can handle it without legislation. He can remove somebody or add somebody to the list. And that's the whole purpose of having the broadband office make the decisions in a nimble fashion. So the amendment, if you really read the amendment, what we tend to do is we look at the statement of intent and we listen to the governor whose bill it is, the governor. Sorry about that, but Senator Bostar, I just gave you a promotion. We look at what the senators tell us the bill does, but we rarely sometimes in this body read the bill. And if you've not actually read the bill, you need to do so because the amendment to me doesn't make any sense. Either we do it or the governor does it, but not concurrently. And our body can request that the governor do this task, or we can ask another agency to do it as well. But to have it piecemealed like this, we are leapfrogging over two different branches of government, and that doesn't work. So what happens when the governor wants to add someone to the list? Can he do that? I don't know based on the way that this bill is written. With that, gosh, is Senator John Kavanaugh around? Did he sneak out? All my good attorneys are gone here. Who do we have left? Maybe Senator DeBoer can answer this. Senator DeBoer, you got an attorney brain. I hope you know the answer to this.
Senator DeBoer, will you yield to a question?
Yes, I will. For legal purposes, I should say I'm not licensed in the state of Nebraska. Yes?
Thank you for that. So I want to talk about separation of powers. Can you kind of walk me through how the separation of powers work in Nebraska and the importance of keeping the different branches separated when it comes to policy?
So generally speaking, it just means that executive powers belong with the executive branch, legislative powers belong with the legislative branch, and judicial powers belong with the judicial branch, and that we try not to do too much commingling. So for example, we don't have a lot of boards where there would be legislators voting at the same time as executive folks.
Could you stick around so I can get you back on the mic on my next turn?
Yes.
Thank you, Senator DeBoer. I really want to talk about how we are leapfrogging across the different branches of government. I think we need to make that clear. And again, I challenge you to really read the amendment and what it does. I know this is Senator Bostar's priority bill, and I never thought I'd be standing and talking against one of his priority bills, but I still have really grave concerns as to whether we should be doing this or whether this is more pomp and circumstance. Thank you, Mr. President.
Senator Bostar, you're recognized.
Thank you, Mr. President. Whether or not a legal brain has looked at the bill. Okay, so to answer a few of the questions that were proposed, yes, the Transportation Telecommunications Committee Council has reviewed the legislation several times. I've met with the committee council as well as members of the committee about this several times. Never has there been a concern raised that this is in violation of some separation of powers provision, nor has there been any concern raised that this is special legislation. I will say that, thank you to Senator DeBoer for speaking to the functions of separation of power and a little bit about what that means and how that works, state of Nebraska. And thank you for voting for this bill. My assumption is that if Senator DeBoer thought that this was a violation of the Constitution, I can't imagine that the senator would have supported it. But I am very grateful for the support. Attorneys also in multiple federal offices have reviewed this legislation, have checked on it, providing their support to it. One thing that I'll talk about when it comes to special legislation that we do here all the time is we'll write legislation that will apply to a city of the metropolitan class only, or a city of the primary class only. There is only one city of the metropolitan class in the state of Nebraska. There's only one city of the primary class in the state of Nebraska. That's Omaha and Lincoln, respectively. However, if we were to write legislation that named Omaha, that this bill is pertaining to the city of Omaha, that would be special legislation. We can't do that. But we can write legislation pertaining singularly to a city of the metropolitan class that has the same effect. If I were to write legislation, if I were to write this legislation and say the provisions of this bill apply singularly to XYZ named company, that would be special legislation. That's not what the bill says. I agree with Senator Blood. I think the members of this body should read the amendment. The amendment says that any company that meets a set of criteria using federal definitions for what equipment poses a national security threat to the people of this state would fall under the restrictions outlined within this bill. Again, it doesn't name a company. Maybe there's one company that meets the criteria. Maybe there's more companies that meet the criteria. That isn't really relevant because it isn't special legislation. And we write legislation like this all the time. I was going to go through a little bit about how we got here with the threats and concerns that have been identified, why this legislation was brought forward, what we're trying to do. But I'll save that for the next time on the mic. Again, I just want to highlight that the governor's executive order is valuable. This legislation is valuable. They do different things. They're not the same thing. No, the governor could not add a name or a company to the list that's in this bill. There is no list in this bill, but you couldn't, the governor couldn't unilaterally amend statutes that we pass. Of course, that isn't possible. So hopefully I've talked a little bit about that. I'm going to go through a bit about the timeline and the buildup to how we got here with the threat faced by Nebraskans. And with that, thank you for the opportunity.
Thank you, Senator Bostar. Senator Blood, you're recognized to speak. This is your last time.
Thank you, Mr. President. Fellow senators, friends all. I guess the thing I'm really not hearing is what exactly does this amendment do differently than the executive order? I'm not really hearing this. And I call shenanigans on the reference to USF. I wasn't sure if he was talking about the University of Florida at first, or he was talking about the Universal Service Fund, exactly what the acronym was about. I hate acronyms. And I'm saying that tongue in cheek, Senator Bostar, I knew what you meant. When you use examples like municipalities, we're not talking about individuals or organizations. We're talking about municipalities and the way state statute is written. Yes, we are allowed to do Omaha or Lincoln because they are labeled within our state statute. And the state statute is written in a way that we are allowed to do that legally. But when you look at this piece of legislation, you're describing a company that you clearly have in mind, whether you admit that or not. And that is also what was said if you look at the transcripts from the hearing. And as a body, that is not something that we are supposed to do. And I question, again, why do we need this bill? And when it comes to separation of powers, what's the competitive advantage of doing this except for maybe supporting something that Senator Flood wanted us to do? I know there's big pomp and circumstance and a press conference and a little bit of media on it. And I'm not sure what we're trying to prove here. Are we tough against terrorists? Absolutely. I had a great terrorist bill several years ago, but basically I was told that everything was already illegal. So why put it into statute, which I can respect. It was in front of judiciary. It was a tough crowd. I understand how important it is to protect Nebraskans against terrorism, but I don't think this bill does a very effective job of doing that. And had we not had the executive order, which I passed out on your desk, and I saw at least 2 people reading it, read the executive order, compare that to the amendment, and then ask yourself the same question that I'm asking Senator Bostar right now. What exactly does this do differently than the executive order? Because I call shenanigans on this bill. I don't think it's necessary. I think if we would have a really good legal mind look at it, that they would be concerned about all of the things that I've expressed in reference to this amendment. And I gotta say, I'm sincerely sorry, Senator Bostar, that I'm standing up against this, but I wanna hear legit reasons, not acronyms thrown at people that they don't know what it is. But when you talk about how supposedly one thing covers something and the other thing doesn't, then explain exactly why, how, and the reasoning behind it. Because we can throw words out all day because nobody listens around here the vast majority of the time. And people are just going to vote green. I know you went around and worked your bill and I heard you doing it. Nobody talked to me until you found out I was against it. Maybe had we had that conversation, I'd feel different. But for what I'm reading and the amount of time I've had to research it, I'm very concerned about it. And on a bill that we absolutely possibly have to move forward on, which I also don't think we have to do either, I feel like we're rushing something that not everybody has a comprehensive knowledge of. Thank you, Mr. President.
Thank you, Senator Blood. Senator Bostar, this is your last time before your close.
Thank you, Mr. President. So the Transportation and Telecommunications Committee Council is just off to the side of the floor. For anyone that is concerned about the constitutionality of this legislation, I would invite them. If you don't trust me, you don't trust my word on it, you don't trust that this has been worked on, fine. You don't have to. But talk to the committee council. Why not? Ask the question. I'm saying it's not an issue. Fine. You don't believe me. Ask someone else. You asked again, what does it do differently, Senator Blood, about what does this do differently versus what the governor's EO did? I'm sorry, that was an acronym. Actually, that was an initialism, not an acronym. Apologies to everyone listening. What the governor's executive order did. The difference is the governor's executive order does not put restrictions on the Nebraska Universal Service Fund distributions. This bill will. That's a difference. That's millions of dollars a year. And no, we cannot write legislation for Omaha. If I wrote a bill and I introduced it and I said, this is for Omaha, and I wrote the city down, that would be special legislation. I can't do that. But I can write that the legislation pertains to a city of the metropolitan class. It has the exact same effect, only the difference being that one is permissive and one is not. If I had written a company's name, yes, that would be a problem. That could be special legislation. But again, that's not what's in this bill. And we do not know that there's only one company. Yes, I know that there's at least one company. And I'm not trying to avoid saying what company it is because I'm worried about some legal consequence. I am not. The reason it came up in the hearing is because a member wanted to know. And I'm trying to do what I can to limit negativity directed toward the particular telecommunication provider that I know is dealing with the challenges of having a network that is full of equipment that is compromising the security of Nebraska. So I'm trying to be considerate. That's the only reason I'm not saying it. If you ask me directly what company it is, I'll say it right here on the mic. No problem. But I'm just trying to be considerate. The question related to this bill is, do you or do you not want state funds, public funds, to go to telecommunication companies that are utilizing equipment that is compromising our security?
1 minute.
My answer to that question is no. That's why I brought the bill. If you have no concern about that, by all means, vote against the bill. The bill isn't a prop. The bill isn't for media. Working with our federal partners, both on the congressional side and the defense side, I know this is serious. That's where this bill came from. I'd encourage everyone to vote for it. I'd be happy to answer any other questions. This is my last time on the mic before it closed, but if anyone else is in the queue, I'll speak to that. Thank you.
Thank you, Senator Bostar, and you are recognized to close on the amendment.
Thank you, Mr. President. Colleagues, the concept behind the bill is pretty straightforward. AM 1181 contains legislation that I had introduced at the beginning of session, LB 63, which would restrict the distribution of funding from the Nebraska Universal Service Fund and the Broadband Bridge Act to telecommunication companies that utilize equipment that compromises our national security. The equipment is defined through FCC, the Federal Communications Commission, rules, their Homeland Security Bureau, essentially, that have outlined components and equipment within the telecom industry that are actively posing a threat to our nation and to our state and to the residents therein. So this legislation would say, if you're a telecom provider, you're utilizing that equipment, we will not give you USF funds, we will not give you Broadband Bridge Act funds. It would also include a provision to annually certify that your network does not contain compromised equipment, and it provides for more flexibility in statute for the purpose of removing the compromised equipment and getting it replaced with equipment that does not pose a national security threat. And finally, all of the provisions in the bill would take effect January 1, 2025. I'll be honest, I think that's too long. However, that is the compromise that we've come to with this bill. And with that, colleagues, I hope that you will take this as seriously as I do. I hope that you will support this. Please vote green on AM 1181, AM 1142, and LB 683. Thank you very much.
Thank you, Senator Bostar. The question is the adoption of AM 1181. There's been a request for a call of the House. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Mr. Clerk?
22 ayes, 2 nays, place House under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senators Dorn and Dover, please check in and record your presence. The House is under call. All unexcused senators are present. The question is the adoption of AM 1181. There's been a request for a roll call vote. Mr. Clerk.
Senator Aguilar, Senator Albright, voting yes. Senator Arch, voting yes. Senator Armendariz, Voting yes, Senator Ballard. Voting yes, Senator Blood. Not voting, Senator Bostar. Voting yes, Senator Bostelman. Voting yes, Senator Brandt. Voting yes, Senator Brewer. Voting yes, Senator Breezy. Voting yes, Senator John Kavanaugh. Not voting, Senator Michaela Kavanaugh. Not voting, Senator Clements. Voting yes, Senator Conrad. Senator Day. Voting yes, Senator DeBoer. Voting yes, Senator DeKay. Voting yes, Senator Dorn. Voting yes, Senator Dover. Voting yes, Senator Dungan. Voting yes, Senator Erdman. Voting yes, Senator Frederickson. Senator Geist. Voting yes, Senator Holleran. Voting yes, Senator Hansen. Voting yes, Senator Hardin. Voting yes, Senator Holcroft. Voting yes, Senator Hughes. Voting yes, Senator Hunt. Not voting, Senator Ibach. Voting yes, Senator Jacobson. Voting yes, Senator Kauth. Voting yes, Senator Linehan. Voting yes, Senator Lippincott. Voting yes, Senator Lowe. Voting yes, Senator McDonald. Voting yes, Senator McKinney. Voting yes, Senator Mosier. Voting yes, Senator Merman. Voting yes, Senator Raybold. Voting yes, Senator Reapy. Voting yes, Senator Sanders. Voting yes, Senator Slama. Voting yes, Senator Vargas. Voting yes, Senator Von Gillern. Voting yes, Senator Walls. Senator Wayne. Senator Wishart. Vote is 39 ayes, no nays, Mr. President, on adoption of the amendment.
AM 1181 is adopted. The call is raised. Mr. Clerk. No one in the queue. Senator Geist, you're recognized to close on AM 1142. Senator Geist waives closing on AM 1142. The question before the House is the adoption of AM 1142. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
41 ayes, no nays, Mr. President, on adoption of the amendment.
The amendment is adopted.
Mr. Clerk for item.
Mr. Clerk for items.
Mr. President, motion Senator Conrad would offer MO 158, 160, 161, and 162, all with the note she wishes to withdraw. Senator Geist would offer MO 171, 172, and 173, all with note she wishes to withdraw those. Senator Hunt would offer AM 1072, 1073, 1074, 1075, 1076, and 1101, all with notes that she wishes to withdraw. And Senator Brandt would offer AM 1162 with a note he wishes to withdraw. I have nothing further on the bill, Mr. President.
Senator Ballard for a motion.
Mr. President, I move LB 563 to ENR for engrossing. 683, I apologize.
Start over.
One job,
Go back
one
to the beginning
job.
of the 4 hours.
Yeah. The question is the advancement of LB 683 to ENR engrossing. All those in favor state aye. All those opposed nay. It is advanced. Mr. Clerk for items.
Mr. President, next item on the agenda, pursuant to the Speaker's agenda, returning to LB 138, I have no E and R amendments, Mr. President. First amendment from Senator Michaela Kavanaugh. Excuse me. First motion from Senator Hunt, MO 314, 315, 316, 317, 318, and 319, all with notes that she wishes to withdraw. First Amendment, Senator Brewer would offer AM 585.
Senator Brewer, you're recognized to open on the amendment.
Thank you, Mr. President. I want to start by thanking Senator Geist for making LB 199 about Ukrainian driver's permits into an amendment for her Speaker priority bill. LB 199 will become AM 837. This bill was one that we were approached with It was very unique in that most of the things that we deal with are Nebraska unique, and at most a national issue on occasion we might have, but this is actually an international issue. LB 199 was heard in Transportation and Telecommunications Committee on February 14th, 2023. There were 18 testifiers in support, no one in opposition, and only one neutral testifier. The bill also advanced 7-0 and 1 present not voting. Why do we need this bill? For those that have been tracking international news, on the 24th day of February of last year, 250,000 Russian soldiers invaded the country of the Ukraine. 6.5 million Ukrainians were forced to leave the country. Many of those ended up in Nebraska. The intent of LB 199, now AM 837, is to provide a path for non-U.S. citizens with an immigration status as humanitarian parolees to be issued driver's license or state identification cards. This includes approximately 1,000 Ukrainians that have resettled in Nebraska due to their immigration status. They are not eligible to be issued a real ID compliant document. AM 837 sets out the requirements to be issued a non-compliant driver's license or state identification card. There are 8 different sections of this amendment that we're going to take a quick look at. Section 9 of the amendment adds the provisions of the non-compliant document to the Motor Vehicle Operators License Act. Section 12 of the amendment sets out the identification documents required for issuance, requires the documents to be marked not for official purposes, and requires documents to be returned if the immigration status is terminated. Section 13 authorizes the verification of documents that are presented. Section 14 outlines who is eligible for the non-compliant document, requires evidence of lawful status, and sets operational dates. It also makes all non-compliant cards issued subject to all other laws related to operator's license and state identification cards. Section 16 of the amendment sets out the requirements for replacement of non-compliant documents. Section 17 sets out the requirements for renewal of non-compliant documents. Section 22 sets out the same requirements for issuing and card design for commercial learner's permits and commercial driver's licenses. Section 26 sets out the same requirements for issuance and card design for state identification cards as for operator's license. And finally, Section 38 repeals the original sections. We have worked with the Department of Motor Vehicles to ensure that the provisions in AM 837 do not compromise Nebraska's compliance with the Real ID Act, while still accommodating the objective of enabling Ukrainian immigrants to be issued a license. I'm asking for your support and your green vote on AM 837 and on the underlying bill of LB 138. Thank you, Mr. President.
Thank you, Senator Brewer. Mr. Clerk, for a correction.
Mr. President, just to clarify, Senator Brewer, I have a note you wish to withdraw AM 585 and spoke to AM 837.
There's no one in the queue. Senator Brewer, you're recognized to close on AM 837 and waive. The question is the adoption of AM 837. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
38 ayes, no nays on the adoption of the amendment.
AM 837 is adopted. Mr. Clerk.
Mr. President, next amendment offered by Senator Mosier, AM 1138.
Senator Mosier, you're recognized to open on your amendment.
Thank you, Mr. President. 1138 is the bill that was introduced as LB 465. I'd like to thank the Speaker for designating 465 as a Speaker priority bill and Senator Geist for allowing me to amend 138. This amendment is very straightforward. It was introduced at the request of the Department of Motor Vehicles. The purpose was to reallocate document fees collected by the DMV. Currently, they're directed to the state fund, state general fund, and some go to the DMV cash fund. So the DMV is a cash funded agency. The bill was heard in committee on January 31st and was advanced to general file on an 8-0 vote. The DMV is fully funded by cash funds and receives no general fund appropriation. The department projects that their cash fund balance will be a negative $1,838,000 plus at the end of the biennium if this legislation is not enacted. For the past several years, the increases in revenue have not kept up with the fixed operational costs. 85% approximately of the agency budget is allocated to costs which are set or passed on by other entities. These costs include salaries, benefits, OCIO technology costs, Department of Administration service assessments, driver's license and state identification card production costs, postage and printing, Department of Administrative Services Bureau vehicles, and mileage and specialty papers for titles, registrations, handicap placards. The reallocation is necessary due to increased costs for fixed operational expenses. The impact of the general fund is $4.3 million annually and has been accounted for in the governor's budget proposal. This amendment proposes to reallocate the current fees being collected by the DMV to that agency to stabilize the DMV cash fund rather than increasing fees for driver's licenses and IDs and the other services they provide. There would be no change in the amount of fees allocated to the county general fund. I ask for your support and a green light on AM 1138. Thank you.
Thank you, Senator Mosier. There's no one in the queue, and you're recognized to close, and you waive closing. Pardon? Members, the question is the adoption of AM 1138. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
36 ayes, no nays, Mr. President, on the adoption of the amendment.
AM 1138 is adopted. Mr. Clerk, for items.
Mr. President, next amendment, Senator Raybould would move to offer AM 1207.
Senator Raybould, you're recognized to open on AM 1207.
Thank you, Mr. President. Good afternoon, colleagues. This year, I introduced LB 738. It's a very simple bill that updates the definition of electric bicycle. The bill was placed on general file with a vote of 8-0 by the Transportation and Telecommunications Committee. I ask for your green vote to adopt AM 1207 to LB 138. It's a good faith amendment, which includes the provisions of LB 738 as well as the committee amendment. I will quickly explain what the amendment changes and why it is worthy of your support. First, it
updates the definition of electric bicycle by adding into statute the national standard 3-tier classification of electric bicycles, also called e-bikes. Second, it cleans up the definition of bicycle in section 60-611, section 1, by changing 2 tandem wheels to 2, 3, or 4 wheels, as we know that many people are enjoying riding tricycles and quadricycles and recumbent bikes. So the purchase and use of e-bikes has exploded over the last few years. Nationally, e-bike sales have jumped 145% from 2019 to 2020, more than double the rate of classic bikes. As more and more people try them, they find them to be a wonderful way of extending their bicycle trips or even their bicycle years. It will be important for our laws to reflect the proper technology. This amendment in no way changes the enforcement or regulations of e-bikes. All it does is mirror what 39 other states have adopted, including all of our neighboring states have already done in updating our statutes as advancements in bicycling technology. It is really that simple, and of course it has a 0 fiscal note. So I kindly ask for your green vote to adopt AM 1207. I am also proud to be a co-sponsor of LB 138 and thank Senator Geist for introducing it.
Thank you, Senator Raybold. There's no one in the queue. You're recognized to close and waive closing. Members, the question is the adoption of AM 1207. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
30 yeas, 1 nay, Mr. President, on adoption of the amendment.
AM 1207 is adopted. Mr. Clerk, for items.
Mr. President, Senator DeBoer would move to offer AM 1218.
Senator DeBoer, you're recognized to open on AM 1218.
Thank you, Mr. President. AM 1218 is a combination of 2 bills, Senator Wayne's LB 796 and Senator DeKay's LB 453. Senator Wayne's LB 796 provides for the Department of Transportation to develop and administer a safety oversight program for rail transit systems. This is a program which is required federally. It won't cost the state anything. The city's going to pay for it if at any point they would need to have one of these under federal law in order to create a trolley or I can't remember what they call it. Anyway, if they have any kind of rail system. This is a Senator Wayne bill that came out of committee unanimously. Again, it doesn't cost us anything. And then I will turn it over to Senator DeKay to introduce his portion of the amendment.
Senator DeKay, you have 8 minutes and 55 seconds.
Thank you, Mr. President. LB 453 has it's an omnibus bill with several changes just to modernize state law. It came out of committee with a 7-0 vote with 1 absent. There are 3 main points to the bill. The first change would be that LB 453 allows the DOT to pay for the Division of Aeronautics Administration to save costs, and the rest of the department, the highway, will come out of the highway cash fund. The second, it will be approximately $2 million will be available in the aeronautics cash fund after the switch for aviation projects, as it will no longer be needed for administrative costs. This money can then be repurposed in the form of grants to Nebraska airports. The second point of this is it lowers the threshold in what counties can contribute to be eligible for state matching funds from the state aid bridge fund from 50% up to 80%. What this does is it revises the percentage that counties are required to provide from 50 up to 20%, allowing more counties to make use of the state and federal grants available to repair their deficit bridges. The third main point of this bill is LB 453 increases the threshold at which contractors can bid in DOT's sealed bidding process from 100,000 to 250,000. What this does is allow small contractors to be able to bid in projects like guardrail rebuild, road mowing, and projects like that. So the NODT has worked on the amendment that will right-size the threshold at which contractors need to go through the pre-qualification sealed bid process. And due to inflation, the old threshold is outdated, and the NDOT believes that the new limit will bring more competitive bids to the state. Thank you.
Thank you, Senator. Senator DeBoer, you're recognized to close on your AM 1218 and waive. Members, the question is the adoption of AM 1218. All those in favor, vote aye. All those opposed, vote nay. Mr. Clerk, record.
36 ayes, no nays, Mr. President, on adoption of the amendment.
AM 1218 is adopted. Mr. Clerk.
Mr. President, finally, Senator Kayla Kavanaugh, have AM 1003, AM 1099, AM 1000, and AM 1001, all with notes that she wishes to withdraw. Nothing further on the bill, Mr. President.
Senator Ballard for a motion.
Mr. President, I move that LB 138 be advanced to E&R for engrossing.
You've heard the motion to advance LB 138 to E&R for engrossing. All those in favor, vote aye. All those opposed, vote nay. It is advanced. Mr. Clerk, for items.
Thank you, Mr. President. Your Committee on Revenue, chaired by Senator Linehan, reports Legislative Bill 727 to general file with committee amendments. Additionally, amendments and motions to be printed. Senator Conrad motions to be printed to LB 775, and Senator Linehan amendment to be printed to LB 727. And Senator Erdman amendment to be printed to LB 393. New A bill, Legislative Bill 565A from Senator Bostelman. It's a bill for enacting appropriations, appropriates funds to aid in the carrying out of the provisions of Legislative Bill 565. And declares an emergency. That'll be placed on general file. Finally, Mr. President, name add. Senator Wayne, name added to LB 50. Senator Holcroft, Decay, and Ibach, all name added to LB 50 as well. Priority motion. Senator Clements would move to adjourn the body until Thursday, April 6, 2023 at 9:00 a.m.
You have heard the motion to adjourn. All those in favor say aye. Those opposed, nay. We are adjourned.